Dobar dan i dobrodošli na Nedelju privatnosti kojom grupa organizacija civilnog društva, Partneri Srbija, Share fondacija, A11, Inicijativa za ekonomska i socijalna prava, Udruženje Da se zna, Udruženje Atina i Beogradska otvorena škola obeležavaju Međunarodni dan zaštite podataka o ličnosti. Nedelja privatnosti počinje danas i trajaće sve do 27. januara, a organizuje se u okviru projekta Zaštiti privatnost, odupri se pritisku, koji je podržala delegacija Evropske unije u Srbiji. Ja sam Marija Šehić, hvala vam što ste danas sa nama. Za Međunarodni dan zaštite podataka o ličnosti određen je 28. januar, datum kad je počelo potpisivanje Konvencije Saveta Evrope o zaštiti lica u odnosu na automatsku obradu podataka o ličnosti. Republika Srbija ratifikovala je ovu konvenciju, kao i njene prateće protokole i usvojila zakon o zaštiti podataka o ličnosti, koji je u velikoj meri usklađen sa pravnim okvirom Evropske unije. U odbrani prava na privatnost, pored institucija sistema i dobrog pravnog okvira, ključnu ulogu igra civilno društvo. U narednih nekoliko minuta čućete šta su u organizaciji Partneri Srbija radili tokom 2 godine projekta. Projekat se zove Zaštiti privatnost, odupri se pritisku. Obratit će nam se Ana Toskić-Cvetinović, izvršna direktorka Partnera Srbija.
Ništa, samo se čuje ono bzzz.
Poštovani gospodine Marinoviću, povereniče za informacije od javnog značaja i zaštite podataka o ličnosti, poštovana gospođo Janović.
Monitor nam ni ne treba, mislim, nama treba u slušalicama.
Poštovana gospođo Norčić-Štancar, opremnice ambasadora delegacije Evropske unije u Republici Srbiji, poštovana gospođo Jovanović, savjetnica u kabinetu predsjednice vlade, gospođe Ane Brnabić. Dragi prijatelji, dragi kolege, dragi saradnici, dobar dan i dobrodošli na Nedelju privatnosti 2022. godine.
Pa da, desi se nekada neko negde zapne za kabel i da se izvuče.
Grupa organizacije civilnog društva 2. godinu za redom ovaj dan obeležava organizovanjem Nedelje privatnosti.
Ne čuje se ništa.
Konferencije koja serijom razgovora nastoji da aktualizuje različite pitanja u oblasti zaštite podataka o ličnosti i prava na privatnost, ali i da širu javnost informiše o ovim pitanjima. Događaj po drugom putu organizuje podršku delegacije Evropske unije u Republici Srbiji u okviru projekta Zaštiti privatnost, odupri se pritisku.
Nema, nešto na trenutak se čulo.
2020. godine sprovode Partneri Srbija,
samo se ne čuje još uvijek od njih, ali se čuje neki bzz. Tu je neki spoj.
Beogradska otvorena škola, organizacija Da se zna, Share fondacija i Udruženje građana Atina, a sa ciljem unapređenja zaštite privatnosti osetljivih društvenih grupa.
Za trenutak se čula.
Sprovodeći ovaj projekat, vodili smo se činjenicom da privatnost nije privilegija, već ljudsko pravo. I da svi bez diskriminacije zaslužujemo da se to pravo poštuje u svakom aspektu
ali i u jednom trenutku se čulo.
Od zdravstvenih usluga koje nam se
pružaju,
preko naših potrošačkih aktivnosti, do radnog okruženja u kome funkcionišemo. Nesumnjivo je da je Republika Srbija napravila značajan pomak u zaštiti prava na privatnost i zaštitu podataka o ličnosti svojih građana. Pre svega to je učinjeno u regulatornom smislu, donošenjem Zakona o zaštiti podataka o ličnosti 2018. godine, po uzoru na opštu uredbu zaštite podataka Evropske unije i takozvanu policijsku direktivu, ali i potpisivanjem i ratifikacijom protokola Saveta Evrope o izmenama i dopunama Konvencije o zaštiti lica u odnosu na automatsku obradu ličnih podataka. U tom smislu možemo zaključiti da je naš pravni okvir u značajnoj meri usklađen sa pravnim okvirom Evropske unije te standardima Saveta Evrope. Takođe, krajem 2019. godine usvojena je Strategija razvoja veštačke inteligencije u Republici Srbiji za period od 2020. do 2025. godine sa akcionim planom za prve 2 godine važenja strategije. A prošle 2021. godine Srbija je započela i rad na strategiji zaštite podataka o ličnosti koja bi trebalo da postavi strateški okvir za unapređenje zaštite prava građana, a posebno imajući u vidu tehnološki razvoj. Međutim, problemi u primjeni Zakona o zaštiti podataka o ličnosti i dalje su brojni. Deo njih dolazi od činjenice da Srbija još uvijek nije uskladila sektorske propise sa ovim zakonom. Ova obaveza propisana je samim Zakonom o zaštiti podataka o ličnosti, ali i akcionim planom za poglavlje 23 sa krajem 2020. godine kao propisanim rokom završetka ovog posla. Uz to i dalje postoji niz otvorenih pitanja u primjeni zakona, nastalih i zbog činjenice da naš zakonodavac nije uzeo u obzir preambulu opšte uredbe o zaštiti podataka Evropske unije, pa su tako neki novi instituti i zakonodavna rešenja ostali bez dodatnog tumačenja i pojašnjenja. Sve to uz nedovoljno razvijenu svest institucija, privrednih subjekata i građana o njihovim obavezama i pravima u ovoj oblasti, kao i neodgovorno izveštavanje pojedinih medija koji ignorišu dostojanstvo i privatnost građana zarad profita, te blage kazne za kršenje zakona, dovelo je do situacije da podaci o ličnosti građana Srbije i dalje nisu adekvatno zaštićeni. Tako je grupa organizacija koja sprovodi projekat Zaštiti privatnost, odupri se pritisku u otvorenoj elektronskoj bazi povreda privatnosti u Republici Srbiji tokom 2020. i 2021. godine zabeležila 142 ovakve povrede. 3/4 ovih povreda odnosilo se na neadekvatno korišćenje ličnih podataka građana. Utvrđeno je da u kršenju privatnosti prednjače javne institucije, a za njim su tu privatne kompanije. Povrede informacione privatnosti najučestalije su u oblastima radnog prava i javne uprave, a izdvajaju se i prava potrošača, kao i povrede u sektoru zdravstva, što je posebno problematično tokom krize javnog zdravlja kakva je pandemija COVID-19. Poseban razlog za zabrinutost donosi podatak da je 11 maloletnika bilo žrtva povreda privatnosti, najčešće od strane javnih institucija i medija. Praćenjem slučajeva povreda privatnosti, ali i izradom izveštaja o primjeni pravnog okvira u oblasti zaštite podataka o ličnosti, te monitoringom medijskih sadržaja, utvrdili smo da je privatnost najosetljivijih među nama najviše ugrožena i da najčešće vodi do povreda njihovih drugih prava. Zato smo radili na unapređenju kapaciteta organizacija koje pružaju podršku osetljivim grupama, kako bi one bile osposobljene da prepoznaju povrede privatnosti svojih korisnika i korisnica. Preko 130 predstavnika organizacija civilnog društva, ali i 120 nastavnika i učenika srednjih škola prošlo je obuke o pravu na zaštitu podataka o ličnosti i mehanizmima zaštite ovog prava. Kako bi sistemske povrede prava dobile svoje formalne ishode, inicirali smo i 4 strateška postupka, uključujući odnosno inicijativu za ocenu ustavnosti Zakona o socijalnoj karti. Svesni da do promene ne dolazi bez informisanih građana koji su spremni da pokreću mehanizme za zaštitu svojih prava, izradili smo i 4 vodiča o specifičnim sektorskim pitanjima zaštite podataka, organizovali niz panel diskusija u lokalnim zajednicama i izradili više promotivnih i edukativnih sadržaja u ovoj oblasti. Ovogodišnju nedelju privatnosti posvećujemo budućnosti. Želimo da razgovaramo o zaštiti podataka o ličnosti u onim društvenim oblastima i poslovnim procesima koji podrazumevaju i obradu velikog obima podataka, a koji prolaze, a svi su izgledi da će u budućnosti prolaziti kroz posebnu transformaciju usred razvoja tehnologija i digitalizacije,
with the development of technology, digitalization, and changes brought about by the coronavirus pandemic. We will discuss the protection of sensitive groups and discrimination as a frequent result of this. We will talk about children who are victims of exploitation more and more in the online world. We will also talk about the sector of health and education, where digital services are developing. We will also talk about whether the new legal framework has brought about changes in the marketing sector, financial services, and e-trade, e-commerce. We will end the week of privacy with a panel on artificial intelligence. And this is contributing to transformation, both globally and also in societies which are trying to catch up with the world. Serbia is one of those societies, and it's not surprising that digitalization has been recognized as one of the priorities in our country. However, what our future will look like and how technology will affect our lives, our rights and our freedoms, and also how important privacy is as a human right and as a social value, should not be decided on by corporations, civil society, or authorities. This is something to be decided upon by us as a community, with 35 members of different sectors. The week of privacy is the right opportunity for us to start talking about those topics. Thank you.
I dalje, kao što je Ana rekla, postoje otvorena
As
pitanja
Anna
u
has
pogledu
said,
primene
there are
pravnog okvira
still
na koje bi
issues
institucije,
outstanding
ali i
regarding the
praksa trebalo da
implementation
daju
of
odgovor.
legal
Zato
frameworks
ćemo
to
u
which
narednim danima
institutions and practice
pokušati da
should give
predstavimo neke od
answers. And
najkritičnijih
that's why
tačaka
in the following
zaštite
days we will try
privatnosti
to
u
present
društvu u
some of
ovom
the critical
trenutku,
points
da
in the
ponudimo
protection of
rešenja
privacy
i ta
in the
rešenja kroz seriju
society
panela
right
na
now
kojima
to
će
offer some
stručnjaci za zaštitu
solutions
podataka iz civilnog
through
i
a series
privatnog
of
javnog sektora
panels
razgovarati
where
o aktuelnim
people from the
pitanjima.
civil and
Ja bih
government
sada
sector will
zamolila
talk
Poverenicu za
about
zaštitu
different issues. Now
ravnopravnosti,
I would
Brankicu
ask
Janković da nam
our
se
Commissioner for the Protection of Equality, Brankica Janković, to take the floor.
Gospođo Toskić, Jovanović, dragi
Mrs.
kolega Milane, draga
Toskić
Mateja,
Jovanović, dear
poštovani
colleague
partneri
Milan,
iz
dear
prijatelji
Mateja,
organizacije
dear
civilnog
partners and
društva,
friends from civil society
medija,
organizations and
hvala
media,
na organizaciji ove
thank you for
nedelje privatnosti i
organizing
prilici da
this
razgovaramo o
Privacy Week and giving us the
možda i
opportunity to talk about perhaps the most important
današnjice.
topics
Kao što Ana reče,
today.
privilegija je
As Anna has
privatnost
said,
nije privilegija, već ljudsko pravo.
privacy is not a privilege, it is a human
Ja se bojim
right.
da nije u skladu sa zakonom, ali da je postala
And I'm
privilegija
afraid
za one koji
that
danas
this is
uspeju
not in
da
accordance
je
with the law, but
sačuvaju
it
pred
has
brojnim
become a
izazovima,
privilege
sa kojima
for
se
those who
suočava
are succeeding in
zaštita
preserving it,
privatnosti,
faced with
uprkos,
numerous challenges
jednom
in the protection of privacy,
pravnom okviru
despite an appropriate legal framework
zaštiti
and
postojanju
appropriate
mehanizama
protection and
za zaštitu.
existence
Dakle,
of
vreme
protection
u kome
mechanisms.
živimo nije ni malo
So
jednostavno
the
za
time that we live in is not
čuvanje i zaštitu
simple
prava
at all
na
for the
privatnost,
preservation
zaštitu
and
ličnih
protection of the
podataka,
right to privacy, to personal data protection, to protection from discrimination. I have to say that I'm afraid that soon, like in the case of tolerance, something that we're dealing with, privacy might become a word that we will start looking for in encyclopedia, trying to find its original meaning in view of the amount of risks for its violation, regardless of dangers that lurk in different sectors, especially now in the times of internet. And it's very important that we will talk about the preservation of privacy in the health sector, in e-commerce, and also when it comes to data pertaining to victims of domestic violence, particularly children, in view of the fact that discrimination is frequently a result of the violation of the protection of personal data. I will also say something more about the threat to this right in the times of COVID-19 pandemic, which has additionally shown how important the personal data protection is. We have not solved all the challenges in this world, in the real world, and we have started to be faced by algorithms into which their owners have included their personal prejudice, which results in discrimination and therefore the violation of personal data protection. The connection between discrimination and the right to privacy of vulnerable groups is demonstrated by the fact that we frequently wonder whether a complaint was sent, that we received should have been sent to us or to our colleague Marinovic. And we start with the proceedings, but if need be, we also send this to our colleagues from the Office of the Commissioner for information of public importance and personal data protection, because the applicants frequently say in their complaints that in addition to discrimination and in addition to a personal trait that is necessary for an act of discrimination, they also say that their right to personal data protection was also violated. And this especially happens, according to a practice, in the proceedings for the protection of gender-based discrimination, particularly on the labor market, because during interviews Our applicants frequently complained that they were requested information which is not of importance for employment, which frequently refers to their marital status, their family plans, and when it comes to LGBT people in the proceedings for the issuance of their civil status for the purpose of getting married abroad, they are frequently asked about their gender or some other information, some other personal information. And for example, if somebody was subjected to gender change surgery, this information is available to different authorities. We frequently reacted because of the way in which some electronic and written media report on domestic violence, because they report on such events in a sensationalist manner, and they make available to the public information about the identity of the victims, which is extremely bad when it comes to children, because this frequently leaves lasting consequences to their development and lasting consequences throughout their lives. If you remember, a few years ago, in one of such cases, a kidnapper of a 12-year girl was arrested. What the media presented for days represented the complete violation of all aspects of personal dignity. Let us not even mention the code of ethics of journalists. And this has become something that is normal. And nobody's even wondering anymore whether they should report in this way or not. Also, technological development has made it possible to get access to different personal data, and citizens frequently, without even thinking about this, without thinking why they are doing this, are providing such data online. You know that there is no free lunch, and we frequently do not think about whether we will put ourselves in danger in different ways by providing our personal data. The algorithms, they make predictions on the basis of our behavior, is something that must make us more cautious, and we have to make a step forward and see what is lacking in our system and in our practice in order to improve the protection of fundamental human rights. Let me remind you, and I think that our colleagues later in the panel will speak more about artificial intelligence, not only for scanning biographies and or CVs and conducting interviews. A few years ago, together with the German Anti-Discrimination Agency, spoke here and implemented the project of anonymous, depersonalized interviews, and we talked with the National Employment Service. It's not always easy to implement. It's easier in private companies, it's more difficult in the public sector, and we talked about possible ways for preventing discrimination on the labor market through demands for sending depersonalized job applications which would not contain information on the basis of which potential employers would in advance discriminate against certain candidates. But unfortunately, this has not come to life, not here nor in Germany fully. There was a lot of resistance, as you can see, even after the adoption of the general of the GDPR. And finally, within this introductory speech, because my colleagues will speak more during the panel about some cases in which we acted when it comes to discrimination as a result of the violation of personal data protection, that the outbreak of the COVID pandemic has suspended or restricted a large number of human rights for the purpose of preservation of public health and opened a discussion on the global level about the justification of measures that are introduced for the purpose of protecting the public interest at the expense of the private interest, nationwide testing, temperature measurements, also certificates on the overcoming of the virus or vaccination. And we are facing in practice a large amount of complaints pertaining to this issue, which refer to the collection of data on the health status of citizens. At the beginning of the pandemic, we also reacted because of the stigmatization of COVID-positive persons that they faced at the very beginning, even the restriction of some of their rights. People simply fled away from those people. They did not want to report their contacts, and this is just one of the examples of drastic stigmatization because of the current health condition. And this is made additionally complex because of the protection of human rights, and we are frequently in a very difficult situation when it comes to issuing our opinions. And maybe the most topical issue is data on vaccinated and non-vaccinated persons, employment, giving advantage or deprivation of rights. Although data on the health of a person are important to prevent the spread of the virus, it's very important to find a balance between the right to non-discrimination and personal data protection, because a measure per se does not have to be discrimination like COVID passes, but in 90% of the cases you might come into a situation where there was a case of discrimination because the measure that was undertaken was not proportionate to the desired goal, and this is the protection of public health. The only thing that I wanted was actually to give you some food for thought and to open some topics for discussion, informing you about some issues that we are facing in different institutions, including the Serbian government. I know that a large number of complaints reach the government, which certainly does not want to do anything illegally. It's simply that you cannot, that sometimes it is not easy to find this balance and to harmonize the protection of public health and minimize the consequences to the economy and personal data protection. And in view of all this, I would like to thank a lot the organizers of this event. All civil society organizations have been our long-term partners, and thank you very much for giving us the opportunity in those few days to raise some issues which pertain to privacy.
The right to privacy, as you have already heard, is at the center of human rights. Societies based on ideas of the rule of law and freedoms are at the forefront when it comes to the respect for the privacy to citizens, and vice versa. In societies where there are trends towards authoritarian forms of governance, different mechanisms are applied which undermine the privacy of citizens. In 2018, the institution of the Commissioner for Information of Public Importance has broadened its purview to the protection of personal data. So this institution is key for the education of citizens in addition to other companies, and also education of economic agents about their rights and duties in this field. Regarding this, the status when it comes to the implementation of the law and the situation in Serbia will be described by Mr. Marinovic, who is the Commissioner for Information of Public Importance and Personal Data Protection. So good morning to all those who are here in person and following this event on the social media. It is my great pleasure and honor to participate at the beginning and at the opening of this Privacy Week, and I would like to congratulate all the organizers of this Privacy Week for this very big, very demanding, and very useful endeavor. It's not easy to organize something like that. I know that very well. We organize another event on Friday, and I'm grateful to the organizers that left Friday for us. So this is the day of personal data protection on the 28th of January. I'm glad that I'm in this select company, and I would also like to take the opportunity of having here my colleague, Commissioner Brankica Jankovic, to say that owing to me, we have gender equality in this event. I attended some events where there were only men on the panel, and the men were panelists, so it wasn't quite pleasant. There were questions about that, so I'm glad that they have contributed to gender equality. 50 years ago, you were not able, regarding your cousins who live in Australia or in the States or in Canada, so you couldn't contact them in person so that you can see them and talk to them in person. Mostly you could talk to them over the phone or write letters, and this has changed a lot in the 50 years, so we can see each other on a daily basis. And thank God the technical advances and the development of technology has contributed to our ability to communicate to everybody all over the world. And we can also follow different events, conferences, sports events, and similar. And it's good. And of course it's good. We are conquering space. But it has its price. It comes at a cost. And I will not say that the cost is undermining of privacy, although it's very often a consequence of what I have mentioned. But it has its price in terms of threatening privacy. It has its price in terms of us being exposed to various things. People read the book by George Orwell, 1984. We watched the movie. We so many books written on this topic. And those books, when they were written, they were treated as science fiction, as something imagined, as fantasy. We now live former science fiction. We live the future that people could not imagine. And just imagine what the future holds for us based on the development of technology in the broadest sense of the word. And the film also presented something else, how you can undermine privacy, how you can influence citizens, how you can control citizens. So the modern world also brings that danger. It's up to us, particularly us who are working in the field of the protection of human rights, and it's up to you, the organizer of this event, and other human rights organizations, to not prevent that. It's impossible to prevent technological advancement, but to challenge that and to put it on the right track and to do something that very often seems impossible in various segments of society. So to satisfy everybody. Nobody has the intention and nobody is willing to prevent technological advances. On the contrary, the Republic of Serbia is making big steps towards development, towards digitalization, towards artificial intelligence, and we have become leaders not only in the region, even on a broader scale. People from the government know that very well in the field of digitalization, and that is good, and it's a development chance for Serbia, and we should use that. But it also brings the question of protection of privacy of citizens. against the backdrop of the development of new technologies. So practically every week we have a new E. Is it e-government, e-health, e-education, and similar? And all these things are making our lives easier, and that's all contributing to the efficiency and to a better life at the end of the day. But it also introduces some new forms of the processing of our data that did not exist in the past. My predecessor in this position, let's say 12 years ago, since 2008, did not have this problem, the problem of artificial intelligence digitalization. We're facing this problem now, and we're not different from the world. The same situation is in the world and in Europe. As Anna very nicely put it, we have adopted our law, which is fully aligned with the GDPR and with the relevant directive applied in the EU. And really, in our discussions with representatives of the EU and in different member states, we always hear praises regarding the normative shape of this law. But the problem is that we have not prescribed certain issues that are contained in GDPR. For example, the preamble. And this explains how the regulation is implemented, and it practically has more text than the regulation itself. It's some kind of a practicum, so we lack that. And there is also something that the EU didn't have in mind when it adopted GDPR, and this is this very speedy development of digitalization. So we need the regulations that would govern the relationship between artificial intelligence, digitalization, and processing of personal data. As the Commissioner said last year during the state of emergency and throughout the situation with COVID-19, we had major issues and major problems when it comes to the protection of the privacy of citizens. We do not have the very best of arrangements in our law, and that's what we lack. And that's why we, as the Commissioner, together with the government of Serbia and the Ministry of Justice, we started working on the adoption of a Public Policy Act, a strategy for the protection of personal data for the period until 2030. And I'm very glad that the government positively responded to our initiative a little bit more than a year ago. And we are well advanced when it comes to the preparatory work, and I'm sure that this strategy will respond to all the challenges and provide for solutions that will help us to resolve these challenges. We lack some data, for example, data on the processing, law on the processing of data obtained through video surveillance, and I mentioned digitalization and artificial intelligence. And we still need to work further on the Personal Data Protection Act. And I really think, it's not ironical, but I really think that we, and when I say we, I mean the entire society, we have not met our legal obligation to align all sectoral regulations with the law on personal data protection until 2020, which was the prescribed deadline. That does not sound well, but it's good. We have identified the flaws of the law, and it wouldn't have been good had we aligned our regulations with such law. So let's improve the law first, and then we can align other regulations now that we have this opportunity, and the strategy for the protection of personal data will help us in that. And I hope that this strategy and our practice will be able to find this very thin demarcation line. When you say development of society, particularly digital, technological development, and the protection of human rights, all human rights, particularly protection of privacy, that at first glance seems as two incompatible items, but there is always a thin line where they can meet and where both requirements can be met. The requirement for the society to move forward, not to lag behind technologically developed systems, and on the other hand, to protect privacy and rights of our citizens. We can do that. And I believe that when it comes to artificial intelligence, I believe that we have enough natural intelligence to respond to the challenges of artificial intelligence. And I'm convinced that we will do a good job. And I will say just a couple of words about the status of the right to privacy in 2021. The Commissioner is continuing its activities. The number of activities is growing, and inspection oversight, 303 such inspections we did. And we set checklists in many places to see what the situation is with data controllers and data processors, how they deal with the personal data protection. We received more than 200 complaints of sorry, we lost the sound. We are developing what is necessary, and we need the assistance of government agencies, and we need assistance from you, all relevant factors, and that's education and training of all in protection of privacy and protection of personal data. When I say all, the first group that I have in mind are citizens whose data is processed, and all those who control the data, who process the data, and these are government agencies. Sorry, we're losing sound from time to time, and I hope that my initiative to introduce personal data protection as the subject in elementary schools and secondary schools, not as subject such, but to include it in some other subject, that this will bring fruit, and that we will educate our target group. And these are young people who have to learn how to protect their personal data in everyday life, and first and foremost in the social media. And I wish you all the success in your work during this Privacy Week, and thank you for your attention. The European Union has made a revolution in this field, and the reform of the legal framework when in May 2018 the GDPR entered into force. So, General Data Protection Regulation. More about that and the recommendations for the promotion of the data protection in Serbia, you will hear from Mateo Čistančić, Deputy Head of EU Delegation to the Republic of Serbia. You have the floor. Thank you. Dear Ms. Stalski-Cetinovic, dear Ms. Jovanovic, Mr. Marinovic, dear Brankica, dear ladies and gentlemen here in the room and in our virtual room. And it's also my great pleasure to participate today in such an important panel organized on the occasion of the International Personal Data Protection Day. And I would really like to thank Partners for Democratic Change in Serbia and their partners for organizing this Privacy Week. And we heard a lot about the situation in the modern world where we share our data globally, and that includes personal data, and we all leave digital footprint when we use websites or the social media, and this massive collection and processing of personal data is forcing us to take care of our personal data and protection of our personal data. And personal data protection is one of the examples where the European Union is the global leader right now, and its framework for the protection of personal data has become a model all over the world, exerting great influence on other continents, countries. Many have reformed their laws in line with the European standards, and GDPR was adopted in 2016, and the protection of privacy of our data has become not only a fundamental right in the European Union, but also a statutory obligation. And the European Data Protection Supervisor has been established as an independent body of the European Union responsible for monitoring the implementation of the rule on the data protection in the European institution. And the European Commission also designated an officer for data protection, responsible for monitoring and implementation of the rule of the European Commission, and also the Data Protection Action Plan has been adopted with very specific guidelines for securing and protecting privacy and securing that in practice. In June 2020, the European Commission considered the first 2 years of the implementation of the regulation and undertook the implementation of various activities in the future, including the promotion and convergence of international cooperation. The Commission will support the current reform processes in the countries outside the European Union regarding new or modernized rule on data protection through the exchange of experience and best practices. There is no doubt that the data is oil or fuel for the modern economy, and data has to be in chain. And our new rules offer the possibilities to make it happen while enabling services to be transformed and to progress, advance into single digital market by sticking to standards and rules for maximum protection of individuals and their data. And that's very important for our partners all over the world and for candidate countries such as Serbia. Citizens, consumers, and companies need to feel safe when it comes to the exchange of personal data in order to maintain trust in the single digital data and personal data protection. And this need is not limited to the European Union only. Individuals all over the world increasingly appreciate privacy and security of their personal data, as the global survey has shown recently, and they believe that it's an important factor that affects their decisions and affects their online behavior. And an increasing number of companies are responded to this request for privacy by voluntarily extending certain rights under the GDPR to their clients outside the European Union. And we heard from previous presenters how much the pandemic contributed to that. As for Serbia, where companies that offer their services are linked to the market, they are those who monitor that. But allow me to monitor certain key events here in Serbia. About some of them we heard from previous presenters. It's very important for us that personal data protection law is, for the most part, aligned with the GDPR, and the Commissioner for Information of Public Importance and Personal Data Protection, and I believe you have mentioned that you have mentioned that in your annual report for 2020, that you actually mentioned the need for the alignment of other regulations with that deal with the personal data processing with the law, and also the number of designated personal data protection officers has remained low, and it's necessary to secure human, technical, and other resources to the office necessary for the efficient performance of the tasks and exercise of its powers. And the agreement on cooperation between Eurojust and Serbia, and there is a Serbian prosecutor who's a liaison officer in The Hague since 2020, and we should cooperation should be established with the European Prosecutorial Office that started its activities in June 2021. And I would like to recall that protection of the right to privacy part of Chapter 23 and Chapter 24, it's a prerequisite for cooperation with judicial cooperation and cooperation with Eurojust. And we know that these chapters will, and the rule of law will be considered crucial for further progress of Serbia in its EU accession. As for the last week's referendum on constitutional amendments, I will have to stress that we welcome this important step necessary for further reforms in Serbia and for further strengthening of independence in the judiciary, and it's necessary for the efficient implementation of the constitutional amendments to also supplement a number of laws, and it should be done on a priority basis through holistic reform of relevant laws in line with the European standards. Also, I would like to commend great work, great expertise of the civil society in this field regarding data protection. And these organizations have implemented a large number of activities, and they have very good analysis, and I hope that these analyses will be considered for future actions. And cooperation with the Commissioner and its team is necessary in promoting the legislation in line with the standards and monitoring its implementation in line with the requirements of the modern reality in Serbia.
The EU delegation in Serbia will, as always, remain a committed partner, committed to cooperation with civil society organizations, Commissioner, and the government in solving different aspects of personal data protection, which need to be reformed within the negotiation process. I wish you a good discussion today and as many as possible, interesting and good conclusions. Thank you very much. And with us today is also advisor at the office of the Serbian PM, Svetlana Jovanovic. Please take the floor. Good morning, everybody. Dear keynote speakers, audience, dear guests. First of all, let me apologize on behalf of the Prime Minister, who could not, but really wanted, because she understands the importance of this topic, wanted to be with you today and talk about privacy, personal data protection. It's good to have events such as this one, and I will now, on behalf of the Office of the Prime Minister, offer and perhaps provide answers to some questions which speakers before me have opened, which they have raised, which are important for us and for all citizens, and let you see in which way the government now reacts and protects your privacy. Let's start in a certain order. As we've already heard, the legal framework has been harmonized, but not fully. What we have been doing in that respect, well, not only that, we are drafting the new strategy on personal data protection, which because the previous one was without the action plan and all the accompanying activities. We have realized that we need to amend the law on personal data protection to improve the system of protection, but not only to amend the personal data protection law. We have already mentioned, and you know, that digitalization is a priority of this government, and that throughout the years we have been dealing with those electronic services and the improvement of the digitalization process in order to become the service for our citizens. What does this mean? Artificial intelligence, electronic services, establishment of registers, mass exchange of personal data, biometric data. This all calls for supervision, organization, surveillance, in order to be able to know how to act. What does this mean? To regulate the issue of processing personal data, regulating the issue of video surveillance. We have now started working with civil society organizations in order to be able to find the right answer to this question, how to regulate the issue of video surveillance in the Republic of Serbia together with all the stakeholders. Biometric data, medical data, these are all the issues that have been raised by the pandemic and which are raised every day because the latest data are very sensitive data and we are all worried about the way in which they are used. We have a law that regulates records in the field of healthcare, and in cooperation with the Commissioner, I would like to praise the excellent cooperation with independent bodies and the service of the Commissioner, because the government and all the state authorities understand that they should not undertake any measures without cooperating with the Commissioner. But what does this mean? for the citizens to know. When we have a new service, we need to undertake certain steps in advance in order to make the service available and enable you to look into your data, which is one of the basic rights, one of the fundamental rights in the field of personal data protection, the right of inspection in order for you to be able to see your data and to be able to react if there's something wrong. What has been done in that respect? We always assess the effect on personal data protection. Before launching any software solutions in the Republic of Serbia, the competent authority implements this risk assessment, views whether there are any dangers and how to prevent those risks and reduce them to a minimum. And in order to do this, this calls for an analysis of the legal framework. The government always does everything in accordance with the law. What is regulated by law, personal data protection, processing of personal data, etc., is done by government authority who are the great data controllers. And this is done in accordance with the law. But when it comes to automatic data processing, certain exchange of data, making the data available to citizens, we conduct the risk assessment, and once all the risks are removed or reduced to a minimum, and when in consultation with the Commission Service, we determine that personal data protection has been reduced in such a way that only the absolutely necessary personal data are being processed. This is when this service is actually launched. I'll just remind you that on International Data Protection, Personal Data Protection Day, we presented a model of a service, Baby Welcome to This World. For the first time, we have created a service where there was this DEM form which includes medical data on the child, and now by introducing this electronic service, we have removed medical data from the civil service, from the officer who needs to actually register all this information. So these are all the mechanisms that the government is implementing. Not only that it wants to improve the legal framework, but it also creates these mechanisms. I will also say something else that is very important, which the speakers before me have not mentioned, training of civil servants. At meetings with civil servants, I have to admit that the first question that is asked is, what does the law say? Can we reduce the volume of data? And this is something that is offered by digitalization. It offers some forms where we might have, for example, in the forms where we might have requested too much information from our citizens, we now require just one or two pieces of information, and these are the measures that the government is currently implementing, and in the process of digitalization is something that we want to do. Supercomputers, artificial intelligence. Before we start using the supercomputer, the government establishes a working group and provides ethical guidelines for the use of the supercomputer. So, through collaboration with the NGO sector, with civil society organizations, and the Commission, of course, we work together on improving certain things, actually seeing in which way the supercomputer and artificial intelligence can serve not only young people, but also us as how this artificial intelligence can be used for the development of state administration, but also for all of us. Training of civil servants. This is something that I have mentioned. Believe it or not, we have here with us one of the educators of civil servants. I would like to thank Mrs. Toskic. She's one of those who actually conduct trainings at the National Academy for civil servants, and who does professional training in the field of personal data protection. We have mentioned the youngest people, the education of the youngest people. The Republic of Serbia is one of the rare countries which has introduced the notion of personal data protection, the personal data, and a special chapter on personal data protection, ways to protect yourself on the internet and ways to preserve your privacy on the internet, because we know that these are the most vulnerable and the most sensitive groups. I think there are a lot of examples such as this one, and there's too little time. I would like to thank you all for your invitation. I would like to thank you for helping us to raise these issues which need to be raised. And as we have in this title, future should be taken personally, it's upon us to protect our own data, and the government of Serbia will do everything it can to protect your personal data from malicious attacks and any abuse. Thank you very much for your attention.
Hvala našim govornicima.
I would like to thank our keynote speakers. We are declaring Privacy Week open, and we're inviting you to start participating in our panels. Media will be able to take statements until 11:30. Then we will have a short break, and then this will be followed by our first panel. We will talk about discrimination as a result of violation of right to privacy of sensitive groups. Thank you.
jednom da vam se zahvalim što ste učesnici prvog panela na Nedelji privatnosti. Dobrodošli na Nedelju privatnosti. U narednih sat i po vremena mi ćemo govoriti o diskriminaciji kao posledici povreda prava na privatnost osetljivih grupa. Naši panelisti su Jelena Kotević, šefica Odeljenja za pritužbe u Kancelariji Poverenice za zaštitu ravnopravnosti. Sa nama je i Milica Novaković, konsultantkinja Saveta Evrope i doktorantkinja na Pravnom fakultetu Univerziteta u Beogradu. Ona će biti sa nama online. Zatim, ovom prilikom su sa nama i Milica Marinković, viša savjetnica za analizu javnih politika A11, Miloš Kovačević, koordinator pravne podrške Da se zna, i Vuk Raičević, pravni savjetnik iz Beogradskog centra za ljudska prava. I ja bih ovaj razgovor počela, Jelena, sa vama. Dakle, da navedemo neke konkretne slučajeve. Sa kakvim se sve problemima vama javljaju ljudi kada je reč o povredi prava na privatnost i zloupotrebama ličnih podataka, koji kasnije ili baš u toj prilici dovode do diskriminacije?
Pa, dobar dan, naravno, svima. Zahvaljujem se na pozivu da ispred Poverenika za zaštitu ravnopravnosti učestvujem u ovom današnjem panelu i razgovaram na jednu veoma interesantnu temu. Dakle, građani i građanke koji su Povereniku za zaštitu ravnopravnosti obraćaju pritužbama za zaštitu diskriminacije, u svojim pritužbama, osim ličnog svojstva po osnovu kojeg smatraju da su diskriminisani, veoma često navode da im je aktom diskriminacije povređeno i pravo na privatnost, odnosno zaštitu podataka o ličnosti. Malo čas dok smo se pripremali na panel, zajedno smo se prisetili, da kažem, najupečatljivijih slučajeva povodom kojih se pred Poverenikom za zaštitu ravnopravnosti kao jednim od mehanizmom zaštite od diskriminacije vodio postupak i slučajeva u kojima je utvrđeno da je do diskriminacije došlo. Česti slučaj da se prilikom diskriminacije po osnovu zdravstvenog stanja građana ili građanke dolazi do povrede prava na privatnost, pa smo tako imali nekoliko pritužbi od strane osoba koje žive sa HIV-om. Jedna od njih je dovela i do toga da se Poverenik opštom preporukom mere obrati svim zdravstvenim ustanovama sa zahtevom da poštuju protokole i da se u praksi više ne dešava situacija kakvu smo imali, a to je bio slučaj osobe koja je živela sa HIV-om i bila hospitalizovana na odeljenju jedne ustanove sekundarne zdravstvene zaštite. Ležala je na odeljenju endokrinologije, dakle, i sa svim ostalim pacijentima koji nisu živeli sa HIV-om. I na njenom krevetu bolničkom je na onoj temperaturnoj listi velikim crvenim slovima bilo ispisana informacija o tome da se radi o HIV pozitivnoj osobi koja, naravno, osim lekaru sa tog odeljenja, nije trebala da bude poznata ni drugim pacijentima koji su ležali na istom odeljenju, pa čak i po građanima koji su dolazili u posetu tim pacijentima. Slična situacija se desila i kada je reč o jednoj ustanovi primarne zdravstvene zaštite, gde se neretko dešava da na kartonu pacijenta stoji ta informacija, dakle da se radi o HIV pozitivnoj osobi, takođe velikim crvenim slovima ispisana, da se ona tako učini dostupnom ne samo izabranom lekaru, već i ostalom medicinskom i nemedicinskom osoblju, pa čak i pacijentima koji se nalaze u čekaonici. Dakle, ovde ne samo da je došlo do diskriminacije po osnovu zdravstvenog stanja, već je došlo i do grube povrede prava na privatnost. Veoma čest slučaj povrede prava na privatnost, odnosno podataka o ličnosti, dešava nam se i u pritužbama koje podnose pripadnici LGBT zajednice, dakle u slučajevima u kojima da dolazi do diskriminacije po osnovu seksualne orijentacije, odnosno rodnog identiteta, kada se obaveza otkrivanja seksualne orijentacije, odnosno rodnog identiteta, praktično često zloupotrebljava i koristi kao razlog za odbijanje zahteva za ostvarivanje nekog prava, odnosno izdavanje nekog dokumenta. pa su takvi primeri veoma česti u postupku promene ličnog imena, izdavanja diplome, potvrde o slobodnom bračnom statusu radi sklapanja braka i slično, a neretko se dešava da podatak o seksualnoj orijentaciji, pa čak i podatak o medicinskom tretmanu koji su u cilju promene pola preduzeli, se u ovim postupcima učini vidljiv i dostupan i licima koji o ovim zahtevima ne odlučuju. I da ne dužim, još jedan ću interesantan primer navesti. Poverenica je u prethodnom periodu veoma često reagovala upozorenjima za javnost, upravo u situacijama kada su mediji zarad senzacionalizma, većeg tiraža ili veće gledanosti o veoma osetljivoj temi kao što je seksualno nasilje izveštavali na način da su prilikom iznošenja informacija iznosili informacije koje se tiču podataka o ličnosti, pa smo imali slučaj nasilja nad maloletnom devojčicom. Znamo i sami da su stranice pojedinih medija pisanih, ali i elektronskih, bile pune informacija o ličnosti maloletne devojčice, koje u svakom slučaju su dovele do njene stigmatizacije i imajući u vidu da se radi o maloj sredini, sigurno nisu doprinele informisanju, potrebe za informisanjem javnosti o konkretnom događaju, već su ušle i u neku sferu koja se odnosi na privatnost, što je naročito opasno budući da se radilo o maloletnoj osobi.
Miloše, vi ste da se zna imali slučaj studije, zapravo studiju slučaja osobe koja je završila proces prilagođavanja pola, odnosno usklađivanja tela sa rodnim identitetom i ta osoba je pokušala da promeni lična dokumenta. Koja je njena priča?
To je baš jedan od ovih slučajeva koji je pomenut zapravo gde su nadležni organi tražili informacije na koje nisu imali pravo. Proces tranzicije u to vreme, znači napomena da je slučaj iz 2017. godine pre ovih vrlo značajnih izmena Zakona o matičnim knjigama i donošenja pravilnika o izdavanju potvrde o prilagođavanju pola, koji su dosta značajni za trans osobe. U trostrukom smislu su oni unapredili promenu polne oznake. U to vreme polna oznaka se menjala na osnovu medicinske dokumentacije kod matičara u opštini rođenja. Nakon toga bi trans osoba promenila svoje ime, lično ime u opštini prebivališta i na kraju sa ta dva rešenja o promeni imena i o promeni polne oznake bi išla u policijsku upravu na opštini prebivališta da promeni lične dokumente i da dobije JMBG koji je u skladu sa njenom novom polnom oznakom, ali i novim ličnim imenom. Znači, bi bili lični dokumenti i to je nešto što mi nazivamo proces pravne tranzicije. U ovom konkretnom slučaju osoba je sprovela medicinsku tranziciju, uradila operaciju prilagođavanja pola koja je u to vreme bila uslov da bi se uopšte pravna tranzicija započela. Sada više nije tako, sva sreća, znači zbog ovih promjena od 2019. I promenila je polnu oznaku, promenila je lično ime, ali onda u policijskoj upravi kada je otišla, znači i kada je trebalo na osnovu ta dva rešenja i da promeni svoje lična dokumenta, službenica mu je tražila da dostavi ponovo svu medicinsku dokumentaciju. Tako da, znači, otpusnu listu koja je sadržavala informacije o detinjstvu osobe, o njenoj seksualnoj orijentaciji, o njenom zdravstvenom stanju, koja se ne odnosi samo na transrodnost, nego čak i na neke druge, kao osoba je, na primjer, imala problema sa štitnom žlezdom i ta osoba je, ta policijska službenica je to videla, kopirala je dokumentaciju. Znači, niz je tu, znači, bilo podataka o ličnosti koji nisu trebali da prosto budu ni u, mislim, kažemo, nisu trebali da budu viđeni ni od strane matičara u opštini rođenja pri promeni polne oznake, što je sada izmenjeno, ali u to vreme je bilo legalno. Ali ovo je definitivno bilo nelegalno da vama policijski službenik pri promjeni ličnih dokumenata traži svu tu dokumentaciju naknadno. Međutim, osoba je bila u situaciji u kojoj je samo želela te lične dokumente što pre, predala je dokumentaciju, iako je pitala policijsku službenicu zbog čega. Odgovor je bio samo jer tako to treba. I osoba nema, na primjer, osjećaj da je bila diskriminisana, odnosno ima osjećaj da je bila diskriminisana, ali nema osjećaj da je to bilo motivisano nekom transfobijom. I kao uzrok pronalazi zapravo neznanje policijske službenice, jer policijska službenica nije bila neprijateljski nastrojena prema osobi. I tu onda govorimo o tome da postoji jedno veliko neznanje među policijskim službenicima i da zapravo su edukacije preko potrebne. I to je edukacija koja će se vršiti u konsultaciji sa organizacijama civilnog društva.
To mi je interesantno, dakle, te edukacije državnih službenika, govorit ćemo o tome i nešto kasnije. A kakav je vaš utisak u organizaciji? Koliko su državni službenici senzibilisani, evo, za ovu temu, kada su u pitanju LGBT?
Ne, uopšte, zapravo, vrlo su nesenzibilisani. Mislim da se radi o tome i mi smo imali nekakve vrlo čudne situacije, tipa nekoliko ulica odavde. Imali smo, na primjer, pošto mi radimo monitoring incidenata koji su motivisani homofobijom i transfobijom, dobili smo dojavu o incidentu da policijski službenici maltretiraju trans ženu u policijskoj stanici. Znači, to se dešavalo na...
An incident in which police officers were harassing a transgender woman, and it was happening very close to us, and we went there. And these police officers kept talking about this transgender woman as he. And then we talked to the senior officers, and he was trying to convince us that they could not discriminate that person because they were educated. They have undergone training on working with LGBT persons. And then I said to the commander, what kind of education is that when police officers were not able to learn the basic thing, the very basic thing? And that is to address the person in the gender with which he or she identifies themselves. And it's not about not organizing these training courses, but they're not organized seriously, and it's a big question how much of that knowledge is acquired by police officers. Abuse of personal data is frequent when it comes to persons who already belong to these vulnerable groups, who have to use the services of social welfare centers or who are in similar situations. Can you mention these some of the examples from practice as the organization A11? Just to mention that these are mostly persons belonging to vulnerable groups already. When we from the A11 initiative, we work with the Roma, internal displaced persons, homeless persons, and other vulnerable groups. But the first groups account for the largest part of the people that approach us, and this is related to exercise of rights belonging to social protection, discrimination, and requests related to rights arising from employment. When we started working on these issues, or until 2 years ago, our focus was on economic and social rights. So we were not primarily perceiving things from the standpoint of protection of privacy. But when we started dealing with this topic, we realized that there is a large number of violations of the right to privacy, and what is typical is that persons from vulnerable groups do not believe that they have any right to privacy. They define that more as a privilege of other groups. And their focus is definitely not on the right to privacy. When you don't have money for medicines or food, then the least of your problem is whether somebody received your phone number or who your first spouse was or your address. So this is not in their focus. So when we when we were seeing cases of violation of the right to privacy, we also encountered resistance to the protection of that right, which is very different from situations where people were discriminated. These persons believed that they were discriminated, and there was will to be protected. And when it comes to this right, we need a lot of empowerment. Benefits that can come from that for members of vulnerable groups are still not sufficiently clear. And I can illustrate that by an example, because not everybody is familiar with the status of Roma, how they live. So I have to make an introduction. When you live in a Roma settlement, you don't have an address. You cannot report any address, and registered residence is a requirement for many rights. So there is a legal possibility to register at the address of the social welfare center, and we were working with people from a Roma settlement, and they were mostly registered at the address of that social welfare center. And we mostly communicated over the phone with them, but there was also a need to send them some letters, some documents, and we sent that to social welfare center with the remark that this letter is for that person. But social workers were opening these letters and read these letters, and we had a case where the letter never reached the person for whom that was intended, and social workers even called us to ask why we wrote that, why we believe that a particular procedure should be instituted, and that's when these people got angry. They felt hurt, and they wanted their their mail to reach them first, and they believed that nobody should read that before them. And we worked with them, and about a month and a half took us to carry out these preparations. It was some 5 or 6 people who were interested. However, eventually we never started the procedure, and the reason for that was their fear of retaliation and the fear of losing some social right. Although the requirements for exercising a social right was not in any way related to instituting the procedure for the protection of privacy, but they believed that they would spoil their relationship with the social welfare center, and they gave up. And there was a person who was even afraid that his daughter-in-law will be affected by the situation where he would embark upon that procedure. So this fear of embarking upon the procedure is quite big. And the conclusion is, maybe when I compare that to the procedures for the protection against discrimination, we can say that maybe a consequence has already happened in those cases. So that's why it's easier to embark upon the procedure. And in this case, the consequence is not so visible. This violation of the right is not so visible. And maybe that's a message that I can draw from our work on such cases.
I don't know if we have Milica Novakovic online, whether we're connected. Hello. Hello. I can hear you well. I don't know if you can see me, because I have some problems with the signal and the camera. Milica, we can hear you really well. We can see that you have camera issues, but it's important to hear you. She is the consultant of the Council of Europe, and she is working for the PhD at the law school at the University of Belgrade. So I hope that you have heard all those examples. How many of them have their epilogue at court? I can see my picture now. I apologize. As regards those cases, they never get an outcome at court, and there are several reasons, and reasons that the colleagues have mentioned are justified. I recently had a situation where, in a wish to help one of the people who live in the same city and who use social protection in order to get greater protection. He gave it up because he does not trust the institutions. I personally, when I contacted the social worker who is in charge of his case, I noticed that this lady actually wanted and was interested in helping him, but that the barrier that he had was a big obstacle. When it comes to court protection, it is lacking in such cases, and this is a major issue. Sometimes I may be too subjective, and I don't really see any justification for such passivity. Lately, we have had a lot of NGOs that have been dealing with the protection of rights. They map problems, which is the first step. They deal with different trainings, either of those who are employed at the state administration or in other places, which is a big step forward. But I also have to say that our colleagues from the NGO sector have big awareness and they know well the standards of protection. So I really have to wonder why they do not make additional steps in order to help the people whose cases have been discussed. Generally speaking, our legal framework is not so bad at all. Preparing for this panel, I went through our mails and I created a list of legal remedies that we have at our disposal. Under the law on personal data protection, there is a possibility to complain to the Commissioner. There's also a possibility to initiate court protection against the Commissioner's decision. In addition to this, there are also possibilities to initiate other types of dispute. Also, there is the possibility to address the Commissioner under the law on the protection of human rights, and she can represent them really well. We know that they can offer really good representation. Unlike some other court proceedings, these two laws also envision revision. And if our colleagues, lawyers, look at this, knowing the law and the nature of revision in our country, revision is not allowed in all cases. Revision is not something that happens in all legal proceedings. And if we bear in mind the fact that revision is possible in the case of this law, we can see that we have a really good legal remedy at our disposal, and it's a pity that it is no longer used. I also observed in case studies that I mapped that there is a large number of cases that have been registered and there is some fear, but I cannot see why no additional steps have been made. It's true that we are very traditionalists, that we are big traditionalists, and this also affects the way in which we are going to use legal remedies. But I think that things are changing step by step, although these are very small steps, I know. It's sad that we have a large number of situations that indicate that even strategic litigation is not necessary because there are a lot of cases where discrimination happens. So I would like to invite my colleagues, lawyers, who have the knowledge and the awareness of the way to protect those vulnerable groups, to help those people. There's also a problem with judicial costs, court fees, and the costs of representation that need to be paid. But this is not something that cannot be resolved in the long run. There are some NGOs that deal with pro bono legal representation. And I would refer you to the Lambda Istanbul versus Turkey case. This is a case that was presented before the European Court of Human Rights, and the application was inadmissible because it was not grounded, evidently. But since in this case Lambda Istanbul could not appeal against the violation of privacy because the data in her possession were not her personal data. The court said that Lambda Istanbul, as an association of citizens that protects the rights of the members of the LGBT community, all the persons whose data were held by this organization had to request legal protection first from all possible tools, legal tools that are available to it nationally, and only then by the European Court of Human Rights, because this is just subsidiary protection of human rights, and the primary protection of human rights of all persons is taken care of by national authorities, legal, judicial authorities. And if I will tell you what the number of the application is, if the colleagues would like to see it, because this is a decision that was reached in 2021. Let me just find it. This is number 53335/08. That's all from me. Okay, there's frequently a difference between things that are on paper and things that happen in real life, and regarding the legal framework and the things that happen in practice. Vuk Rejčević is a legal advisor at the Belgrade Center for Human Rights, and I would ask you to share with you the experience of your client, asylum seeker, and a member of the LGBTI population. I think that we can follow up on this. Yes, as regards the Belgrade Center for Human Rights, we, as the executive partner of UNHCR, have been providing free pro bono legal assistance to refugees and asylum seekers, and we should be aware that asylum seekers are in a very delicate position because they are residing in a foreign state without relevant data, with some incorrect data, or they thought that they would be given some protection which the state cannot give them, and they come from the countries where they were exposed to risk or problems or persecution on different bases. And today I wanted to share with you a case that we had of a client, a former client of the Belgrade Center for Human Rights, who came from an African country to Serbia and who filed the request for asylum, saying that he was exposed to persecution in his country of origin on the basis of his ethnicity and sexual orientation. What was characteristic in this case was that this person never came out of the closet in his country. He never told anybody about his sexual orientation and had to hide it throughout his life. And this was the first time in his life in which he decided to inform people about his sexual orientation in the institution where he sought asylum, in the asylum center. And the reason for this was that he was exposed to certain threats from people who resided in the center, other asylum seekers, because of his assumed sexual orientation. He addressed the authorities in that institution and he gave this information for the first time, and he said that for that reason and the reason of his security, he would like to be transferred to another room or, if possible, to another facility. The result of his secret, and this is a young person who is disclosing this for the first time, was that at a meeting attended by all users of that facility, the person who was given this information, said publicly to all that this man had a particular sexual orientation, that he was gay, stating that the fact that he was gay did not actually give him any kind of privilege, and that this was not a hotel, so that he could not be relocated to another room or another facility. And before we started representing him, and before the case came to us, you can imagine the level of trust or distrust that he had after that, because his problems just increased, the problems that he already had in the facility. He was exposed to discrimination by the people who come from his country, and this is a country where homosexuality is criminalized. And in addition to this, I should say, in order to make it clear to everybody, that under the law on asylum, there is a principle of confidentiality, which means that this type of information may be available only to those who are authorized to have such information under the law. And eventually, after a while, he wanted to talk about this publicly. He wanted to share his story with us as his legal representatives, and he asked us for help to try to ensure that he can be protected from all the problems that he had, and to transfer him somewhere else to do what he has already requested. Unfortunately, we got the negative response, and I would just like to reinforce the level of sensitivity by state authorities. One of the reasons for rejecting the request was that his feminine behavior and his attitude towards others actually provided information to others that this was a gay person, that this was somebody who belonged to LGBTI community. So this type of response is inappropriate, I should say, but as a result, he withdrew more and more. He did not want to participate in the services available at the asylum center. For example, the psychological support was requested only from the Let It Be Known organization, which provided the psychological support. So this created a load of problems, which finally ended by his leaving Serbia out of fear of what might happen to him. It's interesting that he chose to come to Serbia because he saw this state as a state where he would be able to protect his rights. And eventually he chose to go back to his place of origin. Well, he left Serbia because he expected Serbia to provide him with protection, not only because he was gay, but because of some other things that happened in this case. But he knew already, on the basis of some other information, that that homosexuality was not criminalized, that he was entitled for protection, and that he expected that Serbia would give him protection. And as Milica said before, is law always applied in Serbia when we talk about this field? And to people whose right to privacy is violated, which later leads to discrimination, and this discrimination is a consequence, can they seek justice regardless of the legal framework? Well, speaking from the perspective of this man, I can say that he was no longer interested at all whether the law can be applied. He saw that the law was not applied, in his case, several laws, that he was not given protection. And because of this fear, he did not even want anymore to participate in the process. We told him about all the legal remedies that he was entitled to, but he simply refused them. And this is something that we discussed. This is a vortex in which he was, and he could no longer get out. He was driven by fear, and he realized that he did not get the protection that he was entitled to.
How often, based on the experience of employees in the Office of the Commissioner for the Protection of Equality, how often fear plays an important role and makes people withdraw from the procedure? Well, it depends. I can say that the experiences are different. It depends on the social group. I have to say that this fear, at least in the practice of the Commissioner and the number of complaints that we receive when it comes to discrimination based on sexual orientation, does not correspond to the realistic situation in practice. We can say that it happens with LGBTI persons. Regardless of the fact that the law provides for the possibility for the organization dealing with the protection of LGBTI persons' rights, this does not happen so often, bearing in mind that this reason occupies fifth or sixth place in terms of grounds for discrimination, but we know that in practice these persons are faced with discrimination and hate speech much more often. And within a project funded by the European Commission that we implement together with the Council of Europe, an analysis was prepared, and that is about hate speech in the media. And this analysis established that hate speech is most frequent when we talk about women and LGBTI persons. And we held today training for representatives of the media and we want to on this topic, and we want to continue with this training courses for the media once the epidemic allows that. And there others that belong to vulnerable persons are much more empowered and have more courage. For example, persons with disability, as we know very well, for a number of years, disability has been occupying the first place for years now, and there is discrimination against persons with disability, but they are much more empowered, and they approach the Commissioner as one of the mechanisms of protection. And I want to stress, and it's related to the case that the colleague was describing, the law is very clear. The Commissioner provides protection to each and every person. Each and every person can lodge a complaint, regardless of whether it's a citizen of the Republic of Serbia or a citizen of some other country or a stateless person. And in addition to him or her, even without his or her consent, that can be done by an OCD. And in addition, besides the protection against discrimination that is provided by the Office of the Commissioner, there is also judicial protection. We cannot act ex officio, but only based on the complaint. But our practice shows that these warnings issued by the Commissioner in individual cases when we establish discrimination, and also general warnings that I also mentioned when I was talking about healthcare institutions. It was initiated by the case in one of the clinical centers with an HIV positive person. So the percentage of actions based on recommendations is very high. In the case of general recommendations, it's more than 80%. And in the case of recommendations based on individual cases, after establishing an act of discrimination, it's even more than 90%. Let alone the fact that the procedure before the Commissioner is free of charge, that it's quick, and that the form for the complaint is very simple, and it's easy to make it probable that discrimination has happened. And this is corroborated by the increasing number of complaints that the Commissioner is receiving. So it's a testimony of the trust and efficiency. We do not have the powers to punish, but acting on recommendations is reason enough very often for people to approach the Commissioner. And for Milica, Vuk, and Miloš, our interlocutors from the civil sector, there is one more question. Do people know what their rights are? Jelena was talking about that.
osetljive dolaze da vrlo
It
često od toga
depends.
zavisi koliko često
Very
oni
often
dolaze vama da traže
this
zaštitu,
depends on
a s druge
the group
strane
from which
koliko vi sami prvi detektujete problem pa onda.
which group of vulnerable people these persons come. So how often they approach you and ask for protection? I will start. As the colleague mentioned, almost nobody approaches us with a complaint or complaining about an incident in which the person themselves have recognized that their rights have been violated. We mostly face hate crimes and violent incidents, attacks. We have less cases of discrimination and even fewer cases of the violation of the right to privacy. Besides this example of the trans person that I mentioned, and whose right to privacy was violated during the legal transition. Maybe I can remember two more cases of unauthorized photographing and discrimination of gay and bisexual men in blood donation, voluntary blood donation. This is the type of discrimination that has been there for a long time, and despite the fact that many countries in Europe are changing this practice, this is not being changed in Serbia. Unfortunately, the Ministry of Health is adopting similar rule books in some other medical areas, like assisted fertilization. Gay and bisexual men are indirectly discriminated as donors of reproductive cells, and this is very disappointing when it happens in 2019. So you have homophobic legacy. There is maybe some inertia to change it, but when you have proactive adoption of such act, that's an indication of more serious problems. Well, colleague touched upon several topics, and I'd like to follow up on that. And maybe it's the right moment to point to the gender component when we talk about the protection of privacy. And women are more exposed because of the circumstances in our society and the patriarchal nature of society. So women are more exposed to violation of privacy than men. And I would like to specifically mention distribution of private photographs and recordings. It's a very topical subject. And we had a case several years ago when several countries of the region were involved in a scandal that involved the distribution of addresses and photographs. And for example, in Macedonia, this female lawyer that wanted to represent the victims had her photographs leaking to the public. And we have a colleague who is a lawyer here in Belgrade, and it happens to her, and he has to schedule a press conference in order to expose herself publicly and prevent such blackmails. That's something that is typical of this area. And another thing that is important, and I would like to point that out, it's not just about the individuals. They're not the only ones who are violating the rights. We had some civil servants, but very often regulations do not recognize vulnerable groups as persons whose rights to privacy have to be protected. For example, you have homeless persons who will have to go to Kumudrška Street to get shelter because it's so cold outside. And when he is admitted to this institution, he will have to provide a pile of data, what medicines he is taking, what sexual orientation, in addition to some regular data. So regarding this type of accommodation, something can be legitimate, but some of these pieces of information are not really necessary, and it's not right to request that. And when you have a person who has no other option but then to come to the shelter in order to avoid death in the street, then you realize that this person is simply forced to provide a lot of information about himself or herself. And we are giving this information about ourselves, despite the fact that we somehow deep down feel that it is the violation of the right to privacy. Because we know that the persons can think, oh, I depend on that person, and I cannot say you don't have the right to ask this question. For example, in the maternity ward, you are asked whether the conception was natural or assisted, and you're even not alone when you have to answer that question. And so, Vuk, can you tell us how many times you have people coming to the Belgrade Center saying that I think my rights have been violated? Or, to put it differently, do they ask for assistance, or they opt for going for some other rights that they need exercised rather than protecting privacy? For example, we have this person who needed personal documents urgently and decided to give all these documents to the police officer rather than protecting the right. Well, we are coming to this essential question whether people know that they have to share this information or not. Because people often think that they have to provide this data to describe themselves, and they think it's completely right for the government to ask for that, for all these pieces of information. And as Milica said, we often have a situation where people think that protection of privacy is a privilege for some other categories of people and that they are not entitled to that. And very often it happens that people are not well informed about what the right to privacy means and how it can be protected. And through the work of our legal team, not only on the asylum and migration program, but also in other programs, we realize that through communication with people and recognize that some rights to privacy were violated. And we also have these dramatic examples that I mentioned today. People very often approach us when they think that certain violation of their rights happened, but what they do not know is how they can protect themselves. What are the steps that they can take? In which manner it can be implemented, and where they can receive assistance, and what kind of assistance? In most of the cases, they expect some kind of free legal aid because they do not have funds to embark upon some legal proceedings or procedures, and they believe that they have to pay fees for these legal services and so on. So in that context, we see that this situation happening all over again, and then I don't know whether colleagues agree with me, but it seems to be practice. When you present all the possibilities for protection, all the options, to arrive at a result that will be good for them, we still have this question that they withdraw for various reasons and do not want to embark upon certain procedures. Sometimes it's fear, sometimes it's the length of the procedure. They will say, okay, I'll accept this and accept that, just deal with that quickly. And then you draw them attention that the legal system is structured in a different way and that it requires taking certain steps, and then they ask for some time to think about that, and then they never approach us again. And maybe they think that this type of legal protection is not effective.
As I said, the secrecy of the process is something that can avert a person and the costs of the proceedings as well. In order to get pro bono legal assistance, you have to be the beneficiary of social assistance, which means that all those people who are not beneficiaries of social assistance still do not do not earn enough in order to be able to initiate court proceedings. There are some things that are very specific for the LGBT community, which actually prevent them from engaging in proceedings. For example, when we talk about crime, our criminal code also protects the rights to privacy. For example, in the criminal procedure code, for example, you can be accompanied by a person you trust when you report an incident, a person that is not your lawyer. And if you do not hire a lawyer, you are forced to go to report a crime alone. You will be alone with the police officer, so if some kind of secondary victimization begins, if he starts laughing at you because you're gay, it's your word against his. And there will be nobody who will be able to assist you in the process. Also, for example, you will never have a case where the prosecution or the police directorate agree if they start with some kind of proceedings where, for example, something is sent to our organization. No, they will always send this to the person. So these are all factors that actually result in the absence of court proceedings. One of those factors can also be how difficult it is to prove such cases. And I would now ask Milica Novaković to tell us how important it is to prove before the court that some kind of material or immaterial damage has happened as a result of abuse of personal data. I will give you an example. A person who was not given a job because the potential employer disqualified this person by asking a question that was not supposed to be asked, and whether she plans to have children, and she says yes, and she does not get a job. And if she decides to sue him, how to prove material or immaterial damage? Yes, I can hear you. It's a difficult question. That is, it can be answered on a case-by-case basis, because in such cases there is no written trace. Not only the written trace of the interview, but also the written trace of the decision, which would state that this was the very basis as a result of which this person was rejected. I cannot remember the case exactly. I think that it was Russian. It was a case involving a girl who applied for a job, and after the interview with the HR, who was actually externally hired, the HR added her to the Russian network that's equal to Facebook, and through correspondence and some available data available on the internet, the girl who was HR suspected her of being lesbian, the applicant. And in the interview that occurred later, the girl admitted that she was a lesbian, and her application for the job was rejected. There was no written trace which would say that the employer was rejecting her for this job, as a result of which it was actually decided by the external agency. And this was his defense, that this was done by an external HR. But there was some kind of evidence which actually indicated that this person was rejected because of the sexual orientation. If we have a situation where somebody is maltreated at the job that they already have, at work, which they already have as a result of sexual orientation, there needs to be some kind of trace. There is frequently termination of employment by the employer, but this is preceded by maltreatment in different ways. If there are some witnesses that can confirm this, then in this case, this person can be successful in court proceedings. But if you allow me, in connection with something Miloš has mentioned, and this is limited access to reproductive health or whatever it was, I would like to draw attention to an interesting case which is currently ongoing at the European Court. I'm mentioning this case because I was told previously that it would be good for us to have case law, and I wanted to say something about the standards of the European Court of Human Rights. This has not been adjudicated, but it raises some very important issues. It's a case of Dermo versus France. Two gay men wanted to donate blood, which we had such cases in Serbia, according to what Let It Be Known has registered. But when they filled in the questionnaire in one of the French cities, one of the questions was what their sexual orientation was. They said that they were gay, and the next step was to determine whether 1 year before that point they had sexual relations with a person of the same sex. Because under the current French regulations, the person who had sex with another man, that is a man who had sex with another man within the previous years, could not donate blood because this deadline was reduced to 9 months. And this problem was of medical nature, and we will see later in the decision of the court whether this was a medical restriction or not, because this can be applicable on this needless requesting of documents and the determination of health of homeless people, whether they can sue them or not. The second problem that happened was that the French blood agency kept this type of information and used it to perform further triage. For medical reasons, this is sometimes justified. We also have forms that require certain information, and on the basis of this, triage is implemented. But there were several issues here. First of all, these people were rejected because of their sexual orientation, and they potentially had sexual relationships, sexual acts with other members of the same sex, and this might have affected the quality of their blood, although we do not know this for certain yet. And the second problem was that the data of those persons were kept and processed. This case was tried last year or the year before that, but we're still waiting for the judgment. So we would like to see whether there is some kind of medical grounds for certain treatment in those cases where the medical data can be kept, and whether there is justification for keeping and processing this type of information. Milica Marinković would like to say something. When we talked about evidence, this is rather difficult when we talk about the employment process. We have several players in the employment process. The person who is placing the ad, also frequently the employer, some other people, and the person whose right was violated is frequently in a dilemma regarding who has violated this person's right. And it's difficult to collect evidence when you're an individual and the records are kept by the employer. There are some things in the law facilitating collection of evidence, but it happens that potential discriminators try to alter the documents to prevent proceedings. A year and a half ago, a woman exchanged text messages. Maybe it's not bad if we can collect text messages, for example. And this case ended up in the media. I don't know if an application was, if a complaint was filed. She publicly invited her to file a complaint. But this person had a job, and actually it was all okay until she took a sick leave, and this is when they found out that she had children, that she frequently used the sick leaves, and this all went through text messages, and then they complained that she was going to too many sick leaves, etc., which led to her termination of employment through a text message. This is one of the examples that I wanted to mention at the beginning when we talked about discrimination on the basis of gender, where the right to privacy is violated. Then you mentioned that during interviews, women are most frequently asked about their marital status and the plans for having children. And this is something that is not of importance for employment. The Commissioner, because of frequent discrimination in employment, issued a recommendation for measures pertaining to this issue. And I agree with Milica. Sometimes it's not easy to prove such cases, but in view of the fact that we have at our disposal not only evidence filed by the prosecutor, but also the fact that we use all kinds of evidence that can be used in the proceedings, not only things that are filed by the applicant, that is the statement filed, the statements regarding the person against whom the complaint is filed. On the basis of that and some other information, we can determine whether this really happened. And the cases in which we found that there was discrimination in labor and employment on the basis of gender are not fair. There was even a strategic lawsuit, one or two strategic lawsuits that were held by the Commissioner, because such cases are very frequent in practice, especially when women are concerned, both in the employment process and even more frequently, as Maritza said, during labor. If they take many sick leaves, it happens not infrequently that she's either fired after the return from the maternity leave or transferred to another work post, which requires lower education, for example. A woman who is on a maternity leave cannot be evaluated and therefore cannot be promoted in a particular period. These are all cases of discrimination, and in some of them, the right to privacy is violated. I just wanted to add, since we're talking about labor and employment, that there is a customary practice of medical examination before employment. Sometimes this is justified, for example, in the case of police and the military, but for example, in the case of, for example, interns for lawyers and for prosecutors, and these medical examinations also include blood tests which can indicate certain issues. Somebody might have your blood test and they can learn about your illnesses or pregnancy, etc., etc. And this is a practice that has existed for a long time. Let me just note that in 2018 in Serbia, the UN text on business standards in the fight against discrimination on the basis of sexual orientation were translated, and those who think that their rights have been violated can find this document online and read it, because it's referring to what we were talking about at the beginning, and this pertains to the issue of sexual orientation, gender identity, and the questions that are asked in the process of employment. which happens not only in Serbia, unfortunately. Are there any questions from the audience? Yes or no? No. Okay, then I will ask. My impression is that Serbia has more or less good legal framework when we talk about this area, but the problems start when the procedures, the existing procedures are not observed, when the law depends on an individual. Am I right or not? When it comes to the normative framework, we have all agreed that the European Commission also agrees that Serbia has a normative framework in the field of anti-discrimination, which is in line with the EU standards. The responsibility for the fight against discrimination is shared by all institutions, individuals, civil society organizations, and only by acting together. And such activities took place between the Let It Be Known and the Commissioner. A large number of cases occurred as a result of that. Even at one of the press conferences, we said that the Commission's decision was actually a test before the court, the test of whether there was discrimination. And as a result, criminal proceedings were initiated. What is my personal impression, and not just of me, but also by all of those who deal with human rights protection, is that it is more difficult to talk about this issue after the consequences which the COVID pandemic had on human rights. The step back that was taken in this period is very visible because of many restrictions and bans that were introduced for the purpose of preventing the spread of the pandemic and the protection of public health. And there are a lot of debates regarding the limits of the observation of privacy and the protection of public health. We should also say that all the problems that we were faced with before the pandemic, they became even more visible during the pandemic, and they showed how vulnerable, how really vulnerable the vulnerable categories of the society are during the pandemic, and that more should be done in order to improve the position and to protect their rights. We have a dramatic deterioration of the position of women who were otherwise in an unequal position even before the outbreak of the epidemic, and during the pandemic they faced numerous challenges from the unpaid work, which dramatically increased, to the care of the older members of the household, to children who did not go to school for a period, and they borne a bigger brunt of issues in the social protection and the healthcare protection. So I think that this COVID pandemic should actually show us a conclusion that we should do more regarding the rights of some groups in the society.
I agree with this statement that the normative framework is much better than implementation in practice. It's normal. It's easier to write a law than to organize a bunch of training courses where you will teach people how to act. But I believe that in many groups there is room for improvement of the normative framework. For example, in this case, case with the beneficiaries of social assistance shows a lot of discretion on the part of social workers, and that results in the fear of beneficiaries to exercise their right to privacy, because they're afraid of this discretion vested in social workers. They believe that when they decide on the amount of the social assistance for them, that could play a role. And we have a discriminatory rule book on the assessment of a donor of reproductive cells. It's the same today as in 2019, and blood transfusion, it has been discriminatory, and not just discriminatory, but also violation of the right to privacy. It's been so ever since I've known, because they force you to declare some facts about your sexual life. So it's indirect discrimination. So it's an attempt to discriminate a person through some other type of behavior. So they're not asking whether you're a gay person, but whether you practice anal sex. So there is a group which is specially targeted and put in a disadvantaged position compared to others. And this is something that can still be changed in the normative sphere. That would be important for gay and bisexual men. What's your impression, Melissa? I cannot fully agree with the statement that we have full legal protection. It's like two balloons, separate balloons. We're talking about the protection against discrimination, and it's all great, and then the same state, the same ministry actually adopts some other laws that totally contravene the first group of laws. We are talking about, for example, of this law on social cards. We had a chance to talk about that law a year ago in this panel, and we are now nearing the date of the implementation of this law, and things have not changed. And this is quite disputable law from the standpoint of discretion. You have a law that processes at least 140 pieces of data, personal data, and not all the terms have been fully defined. There are still invisible persons who are not covered by the social protection system, and the objective of the law was to improve the social protection system and the exchange it. But when you analyze the text, you see that the only objective is to inform government agencies quicker when a person loses the right to social assistance. I don't see how this law can lead to better coverage of beneficiaries and better social protection. It can only lead to more data being taken by the government agency. If you have to inform about spouses, current spouse, or former, or similar things. We cannot talk about the protection of privacy of beneficiaries of social protection that goes in the right direction. And we have new laws that do not match the laws that are being implemented. And how many times it happened in your practice that you expected a reaction from government agencies and it never came, or it was contrary to what you expected? Just to follow up briefly on what was mentioned here, I also want to point out that the normative framework is good. There is the legal framework, and it's being improved, and I hope it will not be improved. It will not be amended in such a changed in such a way that new laws will be adopted that will contravene the previous one. But there is a serious flaw. We still do not have this anti-discrimination strategy, a new one. The existing strategy was enforced between 2013 and 2018, and we are now in 2022. We still do not have the new document, and I believe that this is a very important document because it can link in the best possible way the legal framework and can target the especially vulnerable categories that are at risk of multiple discrimination. multi-layered discrimination. As for the approach, we have a mixed situation. Specifically, in this example that I mentioned, we approached the competent institutions. There was this initial initiative by our client to approach somebody to submit a request for his transfer, for somebody to inform somebody about what happened to him because of his sexual orientation, and we received the answer that we received. I said at the beginning that the rationale mentioned his behavior, his feminine behavior, as the reason to deny some rights to him. And it's not just the question of acting in line with the law, but the question of sensitization and the question of pointing out clearly enough that these are persons in a particularly vulnerable situation, particularly when we talk about asylum seekers. They're persons who have been exposed to different problems in the country of origin, very serious things, violence, sexual violence, threats to life. Some were targets of potential murders or any other type of violation of rights that imply torture or inhuman or degrading treatment. So you have a situation where somebody is residing in the territory of Serbia, which is a foreign country, and it does not have enough information, and approaches somebody for assistance, and in a particularly sensitive place where the person resides, where they receive food or where they sleep, we find something that is alarming, and it doesn't demonstrate adequate treatment by our government agency in this situation. A question for Milica Novakovic. Can you tell us whether there were cases from Serbia that ended up before the European Court of Human Rights because of violation of this right, because there was no protection in the country? According to the best of my knowledge, there were no such cases. But when it comes to the material, to substantive law aspect of this problem, when applications related to Article 8 of the European Convention are examined, one of the tests that is applied by the court is the test of the quality of laws that the country applies. Although I would just like to draw your attention to the case Dragan Petrovic versus Serbia. Its judgment was rendered a year and a half or two ago, and the problem was related to the investigation. The investigation was conducted against Mr. Petrovic and his wife, and samples of their saliva were taken for DNA analysis because they were suspects in a murder case, aggravated murder. And at the time when they were investigated, only the actions of the analysis of blood and urine were regulated. There was not a possibility to take saliva samples or analyze the data obtained by the analysis of these samples. And this was based on the order of the court to take the sample of their saliva and even to apply force if they offer resistance. And these samples were taken, and based on these samples, it was established that they were not at the crime scene. They could not be placed at the crime scene. They were not perpetrators of the crime, and Mr. Petrovic had to could not get an illegal protection in the country, and approached the European Court. And the European Court analyzed the CPC that was in force back then and established that there was no legal basis for taking such type of sample. But what is important in relation to our context today is the fact that the court analyzes the law that are in force and that are applied in relation to the right to privacy. And so the court says that the provisions that are applied in relation to these rights have to be clear, have to be definable and predictable. And that also implies that they have to be systemically linked and aligned with other regulations. And if there is no consistency between two regulations, it can also that can also result in the violation of rights. And regarding the issue mentioned by our colleague from the Office of the Commissioner about the vulnerable position of women in this period, I would like to point out another case of the before the European Court, Buturuga versus Romania, and that could be very clear. And the number of the application is 56867/15, and the applicant complained about violence by her husband. He committed physical and psychological violence against her. He threatened to murder her, to throw her over the balcony, to stage her suicide. He also inflicted injuries in the area of her head and threatened with an axe, and she reported, and it was medically noticed, identified. And I'm not sure, when he turned on her computer, he actually broke into her Facebook profile, copied all the data. I'm not technically quite sure how that would be feasible, and I cannot give you these details, but he did that, and he also copied all the documents that she had on her computers, including some private documents and photographs that she had. So in her report for domestic violence, she also reported this type of action and asked for expert opinion to establish that it was one of the actions of violence that she was exposed to. And this is a very topical issue, and even today, bearing in mind the technical and the stage of technical and technological development, it's very important to have this in mind. It happened in a Romanian city, and the police there believed that it was totally irrelevant and did not want to perform an expert examination of her computer. Then she filed a separate report on this violence committed in this manner, and they believed that in the context of the overall violence that she was exposed, that was not relevant. There was no connection between these actions that he committed and the previously reported physical violence. But when the application came to the Strasbourg court, the court took a completely different standpoint. The court, it's important to bear that in mind, the court established that the procedural aspect of Article 8 was violated because a priori all her reports were dismissed in relation to the right to the secrecy of data, secrecy of correspondence that was violated, or confidentiality of correspondence was violated, and the government failed to conduct a comprehensive investigation because there was direct connection between the violation of her right to privacy and violence. That is, that the violation of her privacy rights resulted in violence against her because her husband obtained not only her data in public domain, but he also obtained some private personal data, whereas private photographs that were never published on Facebook or any other public network. And the government claimed that only her data in public domain were obtained. So he violated her own privacy, and the domestic court did not investigate the nature of this data, and that resulted in violation of Article 8 in the procedural path. Bearing in mind that any form of violence, if we take into account the Istanbul Convention, is discriminatory treatment, primarily when it comes to women, because it's believed that every such act is very violent because they are women. So this case had to be borne in mind because this case links the issue of discrimination of women, domestic violence, and the violation of the right to privacy. And obviously it can be one of the forms of violence to which women can be exposed. And I'm saying this because in this period when we were all closed and confined, we realized that there is a rise in violence against women, in addition to additional burden on them. And I'm just drawing attention to this case, and it's of general importance. I believe I gave you the number of the case. And then Budruga versus Romania.
This is my contribution because we don't have such cases at Strasbourg, Serbia. They may be a result of the problems that we have with reporting violence and prosecuting different types of injuries. That is violations of the right to privacy, and I think that there will be more and more such cases which will not be just a legitimate use of legal remedies that are available to everybody in the state, but also a form of institutional pressure and the bringing to the surface a large number of issues regarding the violations of the right to privacy that occur, sometimes even without going to court, regardless of the effort that it requires and a large amount of fear. Without this, we cannot talk about the necessary changes. Thank you, and I would like to thank all our panelists. We will have to wrap up now in order to observe the time that we have been given. We talked about the right to privacy of vulnerable groups, and I would like to thank you once again. Good afternoon, everybody, and welcome to the second panel within Privacy Week event where issues pertaining to privacy, personal data protection are reviewed in January. On this second panel today, we will discuss the protection of privacy of children, victims of violence and exploitation. Privacy Week is an event organized by Partner Serbia, which are, let it be known, Belgrade Open School and Athena, where I come from. My name is Milan Aleksic. I work as a researcher and analyst. And Athena is an organization that has been dealing with the fight against human trafficking for some 19, nearly 20 years, and the protection of victims of human trafficking. And today, at this panel, we'll try to shed light on different issues pertaining to the protection of privacy of children, victims of violence and exploitation. Many of you have chosen to observe this panel online through the YouTube channel, and all of you can, if you want, ask questions. So whenever you have questions, please write them in the comment section on YouTube, and we will later collect those questions in the section allotted to Q&A and respond to them. The violation of the privacy of children has been increasing lately in view of the rise in digital technologies, and this issue has become particularly complex after the outbreak of the COVID-19 pandemic. About 750,000 predators are assumed to be lurking around the internet, and they want to engage in communication with children, and through their communication engage in some other abuse, both online and in the real world after engaging in initial contact. After the outbreak of the pandemic, there has been a rise in the number of suspected child abuse, online child abuse cases, and this number has increased by nearly 30% at the global level, by 28%, and in 2020 this has increased even more. And many organizations that deal with this issue and with the protection of human rights have actually said that 2020 is the worst year when it comes to the reports of suspicion of sexual exploitation of children. As I said, today we will have discussions with different people who come from different institutions and civil society sector, and we'll try to shed light on different aspects of this issue. Here we have with us Mr. Mitar Đurašković, Colonel at the Police, Head of the Office for Coordination of Activities in the Fight Against Human Trafficking, at the Police Directorate, at the Interior Ministry. Mitar Đurašković has been an important person for decades in the fight against child abuse, and he is the one who takes the credits for actually giving a strategic swing in the state in the field of protection of human trafficking victims. We also have here Miroslav Jovanovic, the Center for the Protection of Human Trafficking Victims. He's the new head of the Service for Complicated Names, I should say. Yes, we obviously have complicated names of those services. So he is the head of the Service for Coordination and Protection of Human Trafficking Victims, one of the two units within the center. The center is an institution which is in charge of the formal identification of human trafficking victims in Serbia. We also have here with us Sofia Todorovic, project manager of BIRN Serbia, the Balkan Investigative Reporter Network Serbia. BIRN, as many of you know, has been active for many years in numerous countries of Southeastern Europe, and has been dealing with the issues of democratization, rule of law, and promotion of democratic values. Sofia has also been active in the initiative of Young People for Human Rights, Youth Initiative for Human Rights, for a long time, and we can say that she is an important person in the protection of human rights of women and gender equality in Serbia. And next to me is Sasha Stefanovic, director of the network, another complicated name, MOC, the Network of Organizations for Children of Serbia. MOC is one of the most important networks in Serbia. It rallies around 100 organizations from different municipalities and cities in Serbia, those who engage in the protection of children's rights and different aspects of the rights of the child. And I can say that Sasha has dedicated his career to the improvement of the position of children in Serbia. I think that this is enough for the beginning. We wanted to shed light on different aspects of the issues that we're going to discuss today. We wanted to see what the approach is and what the activities taken by the state are in this case. What does the state do? How does it deal with the challenges in connection with the privacy of children, and what civil society organizations do and how they view the efforts of the state, what the situation in the media is, because unfortunately lately we have been witnesses of numerous violations of the right to privacy by the media, where they disclose the identities of children in general and also the children who are the victims of human trafficking. This is a very important and difficult issue because through the disclosure of the identity of the child or another person that has been the victim of exploitation, actually makes it difficult for this victim to recover and to be a member, a deserving member of the society again, to take the place that it deserves. Let me start from Mitar Đurašković. Let's ask him where this issue is on the agenda of the Interior Ministry and the Office for Coordination of Activities in the fight against human trafficking. So the issue of privacy and victims, the victims of human trafficking in this case, to what extent has it become a priority in the work of the Interior Ministry in general, and particularly in the work of the Office for Coordination in particular, because it has been very active in this field, that it monitored the implementation, that it has to take the credit for the action plans for implementation, and that it will be one of the main instances for future strategic documents in this field. Thank you, Milan. First of all, I would like to greet everybody on behalf of the MOI and the Police Directorate. At the beginning, I would like to actually make those assessments more moderate. We at the MOI operate as a team, not only within the ministry, but also with the other state authorities and the civil society organizations. So no individual can do everything on their own. This is important because when I remember the 1990s and some operations of the MOI aimed at fighting what used to be the crime of enslavement, the entry of the police in the facility was monitored, and the girls were there and everybody was with them. Soon afterwards, this practice changed. We realized that we could not treat the girls who were either suspected or real victims of what was not at the time human trafficking, that we could not, we realized that we could not video record them in order to protect their privacy, and we realized that all the efforts of the civil society organizations could be undermined. We saved the victim and found the victim through our joint efforts. But as a result of irresponsible reporting of the media, we jeopardized this person's safety and also her future and recovery and reintegration in the society. And in view of all that, in 2008, 2009, we recorded a documentary. Knowing all that, we protected the victims of human trafficking. We blurred their faces and changed their voices. They had nearly male voices, and we were very satisfied. We worked together with the advisory unit for the protection of victims of domestic violence. Everything was okay, but nobody could recognize the girls. But at the end, you could see the silhouettes of the girls who were going away, and watching the film, the girls realized that they could recognize their own silhouettes. And this is when we realized that we should never give agreement to the victims of human trafficking to participate in any kind of media shows. This was a lesson learned. For us, the girls recognized themselves, they felt bad, and then a movie was recorded and the strategy followed. So we had to change our operations, and today we have instructions, we have the directive of the minister regarding relations with the media, and this is regulated in a serious manner. But we will speak about this more later, but regarding the strategic activities, this strategy, the preparation of the strategy started in 2013, 2014, and in view of this experience, we concluded that despite all the trainings intended for the media, the first textbook for the media was written by Jelena Bjelica, and there was also textbooks of Astra. We also had trainings for the media in 2012 and 2013. But the media and the citizens do not understand this issue, and this was recognized by us. Unfortunately, the situation has not changed very much. We have recognized this as a problem in the strategy, and we believe that the new strategy that will be adopted in 2023 will also focus on this field, on the work with the media, raising the awareness of the public, citizens in general, regarding the improvement of the rights of victims of human trafficking. That's all. I don't know if I have any more time for the beginning. Also, when programs are made within the projects, we also bear in mind the rights of human trafficking victims. And another very important project is something that is implemented by the Ministry of Justice. This is IPA 2016, where the media and police and prosecutors should be trained on the right to privacy. And I think that we can speak in greater detail later on. Yes, we will talk about documents. But during the trainings, our colleagues implement trainings on the safety of children, both those who are victims of human trafficking, but as well as those who are the victims of abuse on the internet. We share this information with children and we warn them about all the risks of abuse on the internet. And this is done together with the National Contact Center for the Safety of Children on the Internet. We warn the children and ensure that they protect their own safety on the internet themselves. This is in connection with what you mentioned, that children are more and more victims of abuse on the internet. What I was talking about is more the undermining of their rights by the media. We have also supported the film Say No, which was made by the Interpol, and it was translated into Serbian. And one of the segments of this film is also the protection of rights of the children on the internet.
In any event, this issue and this topic is something that we will all have to deal with to a much larger extent in the coming years. Because of this steady development of communication technologies and because these different types of recruiting and violence in the online space are developing very quickly and taking on some forms and shapes that they never had before and have not been regulated, and we are not sure how to recognize them. And then the question is raised of how to work with children who are victims of these different forms of abuses on internet, or impersonation, or doxing, or catfishing, and different types about which you do not know how to understand them or how to translate them into Serbian, or how to regulate them in legislative terms, and how to deal with the victims and how to treat the victims of these forms of abuse. And this was a nice introduction, what you were saying, Mitar, and I mentioned that at the beginning. To make reference to this media sphere, to see actually what's going on in the media, and to see how this privacy of victims of different criminal offenses is violated in the media, and to talk about the extent to which the victims are the priority in the work of the media, and particularly of the regulatory bodies in this media sphere, whether this question is well regulated and sufficiently regulated by the legal framework, current legal framework in Serbia. And what I have in mind is the criminal code and the law on information and the law on the protection of personal data. So, Sofia, what is your impression? How much priority is attached to these issues in the work of the media, and why? And I can say this from the standpoint of what Atina is For a number of years, we've been seeing many examples of violation of the right to privacy in the media. I will try not to talk about my impression because we have been able to read different analysis of the media content in Serbia, so the data is available. What we are trying to say when we say that the media reporting and the coverage is not at the satisfactory level is based on different analysis of the contents that we can read in print, in the press, and in the digital media. Regarding the priority attached to this issue in the media, it depends on the type of the media that we are talking about. Some media outlets are paying a lot of attention. Unfortunately, they constitute a minority. Their reach or their circulation is much lower, and the number of people they reach is lower than the majority, compared to the majority of the media outlets that are used by the general population. And this is a small number of the media that are very much paying very much attention to this issue and putting stress on what is the essence of the journalism, that's the story. On the other hand, when we talk about abuse of women and children in this respect, we're talking about the violence mostly, and this can have different forms. And in most of the media outlets, violence as such is treated in a sensationalist way, and this is used for clickbaits to attract as many clicks as possible, so that the media has a lot of visitors, and the problems that Mirko was talking about a moment ago are then totally neglected. What is important is to mention who is affected the most at the end of the day by this. And these are victims. Mitar talked about the disturbance among the victims when they recognize themselves in the films. So the same is with the photos or initials of the victims, or other pieces of data that can easily lead to identification. So very often people have this need or maybe habit to start from themselves and say, well, this data does not mean anything to me. I couldn't identify anybody on this basis. But it's not about us. If somebody is from a small community, then the shape of the hand or a combination of initials and the year of birth can be sufficient to reveal the identity of the person. It doesn't have to be the color of the voice. It can be the way somebody is talking. We all have our idiolects. You can mask my voice or blur my face, but my friends that know me very well can conclude that it's me based on the way I structure the sentences or the terms that I use. So it's important to understand as a reader that that can happen. And this is the type of sensitization that we are lacking in the civil sense and in the media sense. And the media, unlike ordinary citizens, media outlets have much greater responsibility. And it's not up to the individual media. We have a small number of the media outlets that pay a lot of attention to it, that stick to professional standards, that advance them in line with the development of technologies. And that is also very important, because we have to bear in mind that technologies are not only developing all the time, but they're also developing at the pace which prevents us from creating new mechanisms that can protect a victim or protect against identification of certain details. So this is the speed that we are competing with, and we are always behind. And this bunch of manuals that we have, they are sufficient. We have enough analysis, and we have enough manuals. They have to be improved, of course. They have to keep pace with the technological development, but I believe that the amount of communication is not sufficient, and this self-regulatory aspect in the media community, because I believe that we have media laws that are very clear when it comes to what is considered to be ethical coverage or ethical reporting, what is permitted and what is not permitted. But what is not sufficiently good is the area of sanctions. And in the past several months, and these were not cases of human trafficking, but they were cases involving young people who committed suicide because of what is happening to them in the virtual world, and the reporting of the media and the coverage by the media of these events brought their families into a very disadvantaged position. But I would like to leave that for the second part of the panel. When we talk about women and young girls and violence against them, we have to include the education of parents and broader family members also into the education, so not just young persons. So this is we have this generation gap there, and their parents cannot understand the amount of the danger that can be behind these events online. For example, I remember these campaigns, Say No to Drugs, when I was a high school student. So maybe that type of campaign looks like, seems not to be very particular, very inventive or particularly innovative. That works. And when I look at young children today, I see that mobile phone is the whole world for them, and I don't think that it's necessarily bad. And if we are not just criticizing young because being online all the time and just reading things online, we're simply not recognizing the fact that it's part of their lives, this digital world, where they can be also named and shamed, and that can affect their lives significantly, what's happening online to them. Thank you, Sofia. During last year's 16 days of activism, we had that message. Virtual is real, and it still resonates even today. And we cannot say that what happens in the virtual space stays in virtual space. Even if it were so, it would have very serious repercussions. And it has serious repercussions on processes in the physical world. For all persons in that virtual world, not just children. We also participate in the virtual world by participating in this panel today, for example, whether we like it or not. And there is another important question that you touched upon, and it's the identification of individuals with certain situations. Actually, the problem of being able to identify a person based on the pieces of information published in the media. And there is also an explicit identification of person. Well, yes, that's an explicit form of violation of privacy, and this is definitely a situation to which regulatory bodies should react by themselves. They should not wait for a reaction of other actors. And that's where we are failing. This control within the media community has to be stronger, but in order for it to be stronger, this question of protection of victims of criminal offenses or members of vulnerable groups, this has to be established as a conditio sine qua non and the absolutely first priority. And this issue of campaigns and the reminder of previous campaigns is actually the introduction to what I wanted to ask you, and it is to think about some recommendations for all of us and for the community that would like to deal with these issues and that would like abuse of children on the internet, online abuse of children to be reduced, to recommend what could be done in the coming months and years and what would be good to do in the coming months and years. And before that, we would just like to say a couple of words about what the Center for the Protection of Human Trafficking Victims is doing. And that could be a question for to which extent is this issue of privacy victims or persons at risk, because you have a large number of reports of suspicions and not of human trafficking, and not all these reports resulted in the identification of persons as victims of human trafficking. I want to ask you about the extent to which this issue of protection of privacy is a priority for the center and in priority in the work of the center with other institutions. It's a very important question. We're talking about children. We have this statistical piece of data that 1 in 2 victims of human trafficking is a child, has been a child in the past 5 years, because we had a small decline of the share of children among victims of human trafficking, and then we had a sudden surge in that share. And we talked about that also through the law and the social protection, and we talked about that also sort of standard operative procedures, and we have our internal regulations, but I don't want to dwell on that. I want to say something that is important. When we look at the causes and how this data is revealed, there are several typical causes. One is bad intention or bad faith. That's what traffickers are doing, and they're using that to blackmail the victims.
The second is ignorance or carelessness, and this is what happens among some civil servants and activists. People accidentally disclose certain data. We are trying because we cooperate with a lot of players. And when it comes to child protection, we cooperate with the police, the prosecution, social work centers, NGOs, there is welfare institutions. And we send all sorts of information to them. And we always wonder what the minimum they require is for performing their function and for protecting the data of our beneficiaries. And this is also something that limits us and defines our work. On the other hand, we are trying to train people who cooperate with us from other institutions, because this is another reason for the disclosure of personal data, curiosity. This is something that is only human. When we see some bombastic headline, we simply stop and have to look at it, regardless of what we feel about it. So welfare center workers probably would like to hear something more about this story. They are interested in certain things. Or a doctor at the hospital, when we take our user there, although she's a victim of, because of the fact that she's a victim of human trafficking, she has certain rights. For example, we have to inform the gynecologist in order to exercise more caution, but the gynecologist does not need to know everything that happened. And these are the things that we use to regulate ourselves and also to inform people, to get information that those people absolutely need. I would like to say something about deliberate or accidental disclosure information about a victim. We had a case, and this is one of the most moving cases in the history of the center. We worked together with a team. This was a case of a girl who was sexually abused by her father, who forced her to prostitution with other men. And this case ended up in the media, and I tried to create an analysis in order to see what I can find out about her from the media. I found texts on different portals and some clips from different shows, TV shows, and I, for example, opened the first text, and the first thing that I saw was the photo of the father, the abuser, whose face was blurred. It was true that I could not see his face, but I could see his clothing, I could see the shadow, and I saw everything that was in that house, because the photo was taken at the house. But when I scrolled down, I could see his name, family name, and the address, because they lived in a small village. And this is where I could have ended up my investigation. But I wanted to look more. What I could find out about this girl. I could find out what the name of her father was, what her name was, when he was born, when she was born, how old she was, to find out the first letter of her name, the name of the village where she lives, which is very small, to find out what her house looks from the outside and from the inside. And these are the things that pertain to her identity. So everybody in that village and in that neighborhood could know who it was. And when we look at the information about the nature of this traumatic experience, whether they were true or false, this was disastrous. The words that they used, some kind of quotations, the words of the abuser, also the words of the neighbors, the family members who nearly judged that girl. And after that, we have some ostracism of that girl because she was expelled from the village. We will talk about this, what it means to disclose the identity of the victim, for the victim, and her recovery, as I said at the beginning, regardless of whether the information that we can find in the media is correct or not. It's enough for the child to be identified or to be identifiable, as the law says, to make the circumstances for her recovery much more complex, regardless of whether the media writings are correct or not. We'll go back to the consequences of such reporting, to the work with victims, and let me ask Sasha what the protection of child victims of exploitation looks like, because as we've said, your center rallies a lot of organizations that deal with the protection of children. How well is this issue regulated in our legislation? I will remind you that last year the Committee for the Rights of the Child of the United Nations adopted Commentary 25 that refers to the rights of children in the digital space, where signatories to the Convention on the Rights of the Child, which Serbia is also a signatory of, are invited to adopt solutions that will protect or at least improve the protection of children in the online space and to protect them from all the risks and negative forms of use of the internet and different forms of abuse that we mentioned at the beginning. So from the aspect of the civil society, what does this topic look like in Serbia? Is it sufficiently well regulated, and what can be improved? Thank you, Milan, for your invitation and for allowing me to talk about this topic. The topic of privacy of children is important from the aspect of us, those who work with children, evidently because we work with them directly or indirectly. The network now has more than 100 members. And outside of that network, there are thousands of different associations, and those associations were created out of the need, inspired by problems that can be observed in the community, in the families, problems with children. It is actually a result of an altruistic need of the man to respond properly to the problems of children. But in time, even when the intentions to help the children are the best, even those who want to help them, even if we want to help them, there can be abuse, there can be problems, and abuse can happen. And this means that we are not immune to the risk of abuse. And we receive scandalous information about this, historical information that certain religious communities cover up different things that happen. And for that reason, at one point, as a reaction to all those issues, we realized that every organization that works with children, or an association, whatever the level might be, should try and be committed to ensuring safety of all children on the part of their employees. We think that this is self-explanatory and this is obvious, but it obviously is not. Let me just mention two examples from last year. The School of Acting and a research center that has been working with children for decades, and we found out certain things endangering their reputation. We found out that children were exposed to sexual exploitation and abuse. So all organizations need to develop something that would be the policy of looking after the children, which means that employees should know how to react if something happens and who to inform. We need to ensure that these procedures are implemented in a confidential way and in a way that would not inflict greater damage on the child victim than the damage that already exists. We frequently do not think that there are numerous reasons for somebody not to report it. When we observe this from afar, we wonder why they have not reported this for such a long time. But we do not think about the existence of reasons why these children should not report it, and also the existence of circumstances that prevent our colleagues from reporting it. I'm speaking about this openly. Although the situation is not favorable for the child, we should be aware that a large number of colleagues will try to conceal this because they're afraid of dangers to their reputation. And we could see that people within an organization were afraid, and they were afraid that if somebody found out about this, that this would be their end. And that's why we should frankly say that risks exist always, that we should do everything that we can to reduce those risks and to prevent them, to install some rules within our organizations. And as regards the legal framework, it has to be changed to be affirmative. A process is ongoing. Our organization has implemented an analysis in order to find out where the gray zones in the legislative framework are. We don't think about this, but there are many organizations, companies that come into direct contact with children, and we do not really regard this seriously, usually. But when a problem happens, we realize why those gray zones are very important. Organization of different events for children, camping, different schools, transportation of children, guides. Why should they know anything about how to look after the safety of a child? But when we realize what can happen, we always have to talk about potential risks and point to them. And this is a good opportunity for informing and inviting parents in order to create this demand on the part of parents. Each parent holds the safety of their child as their #1 concern. And when you send a child somewhere, you should get information on whether they have a procedure in place that would reduce or prevent the risk for the safety of the child. And this will ensure that the associations and the sector that deals with children should be more serious in their efforts in order to improve the situation. The second part of the issue is how to implement all this. Of course, information is important, trainings are important, education is important. We have been talking about this. Maybe to follow up on this, you mentioned how to report something, why something wasn't reported immediately. For example, you filed many reports on the violation by the media to the Press Council, and let's see what the outcomes of those proceedings are and to what extent we can ensure a reduction of such cases. Well, here we can see the role of the association as a corrective factor. People are aware that we should be open, frank, but it's easier to turn away from the problem. Because if you're loud, if you draw everybody's attention to you, then you hold the burden of proof, and then you have to wonder, well, why did I need this? Let's give somebody else the opportunity to deal with this issue. And that's why there is a need for having some regulatory bodies in place, such as the Press Council. This is a good initiative. People from the media sphere should have their body, which has their code, but they have some limitations. For example, if in the media we observe an individual issue, and if we see that the privacy of a child is endangered, we cannot draw their attention to it. We have to find a way to tell them that even if this is an individual case, we have to present it as a problem of all children, which it actually is. It is a problem for every child in our country. And then we tell them that this is a violation of the code, of conduct of the media, violation of the law on media, and the consequences that it can have on children. And what is interesting, and the colleague has mentioned this, is that media receive information from the investigation. How does this information reach the media? I don't know. I'm naive. It's either they receive this information or they make the information up. Last year, well, actually, we've always had them, and we will always have such individual examples. And now we have to wonder where the boundary between the right of the public to know is, because there are some issues, for example, human trafficking, pedophilia, child abuse, sex trafficking, etc., etc. These are the issues that affect families and the society, and we need to talk about this. But where is the boundary? How to talk about this problem as a problem that is important for a society? And do we really need, when we talk about those things, to see the photo of that child and to go through the traumas of that child? Maybe we should tell people openly, imagine if this were your child, how would you feel if somebody talked about your child in this way? I don't know, maybe we should be more open and speak more frankly and talk about things in the way that they are. Tell people this is brutal, this is horrible, this is a crime, and you're vultures. And do we really need to know all those details of what a child has gone through in order to satisfy our curiosity as human beings? This is a matter of approach and how to change it. We will talk about the consequences, what happens with children. Sofia wanted to say something.
Yes, because some very important things have been mentioned here. I would proceed from the fact that an example was mentioned that the media are inventing information, or information is leaking from the investigation. And these are not only criminal offenses where information from the investigation is leaking. So we should talk about that as a state, as a government, and we should talk openly. If we have a case of information leakage from the investigation to the media, and if confidential information reaches the public, that is something that is prescribed by the situation which is prescribed by law, for which there are rules and procedures, and we have to act upon that. And the agility of the state has to be greater in such situations. And the second thing is the responsibility of journalists. This is not something strange or something non-existent or not mentioned in our laws. All journalists have their sources, contacts from whom they receive information and so on. But does it mean that each journalist should publish each information received from his or her source from the Minister of the Interior? Oh, absolutely no. If the source violated the law and provided information that shouldn't have been provided, then the journalist has to measure that. We have to balance this public interest and confidentiality. Like in the case of Petnica, we cannot put anything before the protection of our children. And so there is no one in this country who would accept something like that. So we always have to be clear about the value that we are defending and about the value that is absolute in this balancing act. Journalists are responsible for what they are publishing. They are responsible if they publish false information. They have to think about their sources, and they have to think about the information they are publishing. Also, we have in the law on information this provisions related to the relationship between editor and journalist. And a journalist can refuse a task. So we have a responsibility as individuals and professionals in certain positions. So I really believe that when we talk about a topic, we have to talk about it in a way where we recognize that everybody has some sort of power, a small amount of power that they can use and protect, for example, somebody who is the victim of human trafficking. This is the responsibility that we have to talk about. It exists. It is prescribed by law. For some reason, we are just pretending that people are so responsible and they don't have the right to say no. They have the right to say no, and they have the duty to say no at some point, and that applies to journalists that are writing about this topic. In the case of Petnica, we had situations where the media outlets were reporting more about the trend, the tendency to destroy Petnica, and we were not talking about how to make it better, how make Petnica better. On the one hand, it's awful what happened, but on the other hand, it's good that we got an opportunity to improve a place where people, where our children are spending time learning and spending time with certain people. So how to improve their procedures and how to make this place better. We have to think about the possibility of children being exposed to violence even in the circles of trust, and there will be always this risk, but we have to work on taking all necessary steps to increase their protection. And that same applies to media. BIRN, for example, organized 3 training courses for young journalists last year from the entire region that were related about the reporting on human trafficking victims. So that requires cooperation between the media and the organization involved in these matters. These are things that are extremely important. There is some knowledge that the media outlet does not have and wants to import that and acquire that and convey that to its journalists, and there has to be this exchange of knowledge and skills, which is constant. Regardless of the institution where violence happens, it does not have to be a taboo. Yes, it's not a taboo, but we have to pay attention how we report on that. Yes, and many of the things that you mentioned are provided for in the Code of Ethics of our journalists of Serbia. And just to remind our viewers, online viewers, that they can ask questions in the section on comments. And now a question for Mitter. We were talking about the regulation, and a whole range of problems were mentioned. The problem of information leakage has been discussed for years, and the state has recognized that and included that in some strategic acts. And the Minister of the Interior adopted certain procedural acts, such as standard operational procedures and certain instructions and guidance. But what is the effect of these documents in terms of protection of privacy and protection of information possessed by the Ministry of the Interior, and what is the effect on preventing the leakage of such information? I have to say one thing first. I'm pretty sure that police officers and prosecutors who work on detecting, prosecuting, and saving human trafficking victims definitely do not want, when they finish their job, when we reach the victim, when we save the victim, when we include civil society organizations, they don't want the victim to be additionally jeopardized. So all of us who are in this chain, we don't want to expose that victim again to some danger or threats or rediscrimination or traumas at the end of the day. So this is about the leakage. I don't know where it leaks, but all our institutions are very aware, and that's why they're fighting that, because that is violation of the fundamental human right. It's not just a crime against humanity; it's also protecting basic human. I had to make this comment because it's leaking in very general terms. Well, who is it leaking from? We have specialized centers, we have specialized civil society organizations. So, We have to deal with that. And I wanted to comment that and to make it clear. As for the ministry, through the twinning project, we started working on the guidance for treatment of human trafficking victims, and bearing in mind that in our meetings that we had in our task force, we were pointing to these cases that are really dramatic. And in some previous period, we were thinking that there is no difference between human trafficker, who is exploiting the vulnerability of the victim, and the media outlets that are also exploiting the vulnerability of the victim. It's almost the same crime. So we incorporated into this guidance that is mandatory on all employees of the Ministry of the Interior, so not just specialized unit, but also our media communication department and spokesperson in police directorates. And I would read item 16 of this guidance. It was adopted on November 15 last year, so it entered into force, and it's relevant for our questions. So I will read this item and I will add something more after that. So employees, during the preparation of the press releases, will pay attention to the rights of the victims of human trafficking, particularly the protection of their dignity, physical security, and psychological integrity, and also the rights of the victim in relation to the to the law on the protection of personal data. And in addition to that, through the IRC project, we prepared together and agreed upon that. And we agreed for all the institutions who are, that are first responders and then have first contact with victims of human trafficking to give the information to those persons about the rights of human rights. That's where we incorporated the right to privacy in this issue. And so the attachment to this guidance is also the information for human trafficking victims. And that also includes the right to confidentiality, the right to privacy. And according to this guidance, each police officer is under an obligation to give this written information note to human rights, human trafficking victims. And it's also translated into English. GIZ translated it into 15 languages, IRC into English. And we included the languages of frequent human trafficking victims, and translation into Vietnamese is on the way right now. So as for instructions, this was it. And another important thing, the minister recently issued a directive on working with the media, communication with the media. So, and that has been so ever since I've been with the ministry, so that the police officer cannot communicate with the media without the approval of the superior officers. So any communication with the media without such authorization is misconduct or even a criminal offense. So in any way, spokesperson or PR persons can speak to the media only based on approval. And that's how I worked ever since I was employed with the ministry, like 1997 or so. And what about the information that is basis for investigation by the ministry? Well, that's a different story. If the police directorate provided information that there was a case of human trafficking and the victim is a minor, then the media start asking questions and trying to get some information. And unfortunately, as Miroslav said, and as we discussed before, there were such cases where we simply saw no difference between a human trafficker exploiting the victim and a media outlet exploiting the victim for the sake of a click or ratings or profit. They're exploiting this tragic fate of a person. And not only at that point, I remember a year when there was this big paper of this size was published. It was a long time ago. They put the name of the girl. The girl was of age. She was 18. But the story refers to the period 2 years before that, when she was 16, and she was exploited in the country, the vicinity, neighboring country, and they put her picture on the whole page. And we responded, and then the editor sent a fax on 3 pages speaking that it's the freedom of the media, that nobody is authorized to exert influence on the media. That was their assessment. And we said we saved her, the police, the prosecutor's office, the court. And what if 10 or 15 years a child of that girl sees this on the internet or reads the media and finds that it's also a crime? We were talking about this balance between public interest and exploitation. And it's important to say aloud that revealing the identity of the victim and revealing the details of the exploitation is definitely not in the public interest. And the public has no interest in knowing the details of what happened to a person in terms of violence against the backdrop of human trafficking and what exactly happened to that person. What is a particularly difficult circumstance for a victim is revealing the identity of that person, of that victim. So Miroslav, if you can say just a couple of words what it means when it comes to the treatment of the victim when his or her identity is revealed. And we know that it's that this name is not revealed only in one media outlet, but it's simply impossible to detect all the places where the information about the identity is published. So there is, once a victim's name is in the online space, then there is no right to be forgotten. Yes, and it's not just about the victim, but many other actors. When we talk about this kind of situation, this is one of the most traumatic experiences, particularly when linked to some type of sexual abuse. And these criminal offenses that also involve some sexual abuse are reported to the lowest extent. The assumption is that less than 5% of such offenses are reported. Why? Because it's deeply traumatizing, and we know from our experience, victims are very often more afraid of people finding out what happened to them than being afraid of what will happen to them in relation to the human trafficker. And when people find out about these situations, there are 2 types of reactions: condemnation and pitying a person. And both are a heavy blow to the identity of the victims. So at the point when people hear about what happened to them, in the eyes of their community, they stop being students or sports girls or friends. They become persons who had this or that experience. And with the change in the perception of their community about them, their own perception of them is being changed. And this results in the internalization of shame, and it's related to the post-traumatic stress, which is one of the most difficult consequences in such cases. And these consequences can be redressed it's very difficult to redress these consequences, and these consequences are transferred on a transgenerational basis, and they have effects on future generations. That's why it's extremely important to protect the identity of the victim and not to reveal their details of their experience.
I don't know if we have any questions from the audience, from YouTube. Well, they tell me that we don't. In this last round, I asked you to think about possibilities for improving the protection system regarding some recommendations. A question for Sofia. You spoke earlier about having more trainings, targeted trainings, but where do we see this meeting point between different players, civil society organizations, media associations, government authorities, in order to treat this problem from different sides? What can they do in order for us to take a good path? I've already spoken about this in the previous round. I think that this exchange of experience by different players, different institutions, I think that each and every one of us have the separate expertise that differs from the expertise of others, and maybe the development of some programs that would have targeted audience for journalists, for young journalists, for middle area professionals, for editors, because the role of the editors is of extreme importance. Editors are those who should stop you from publishing a newspaper with a photo of the girl on the cover page. The editor is the one who should say, well, this will not go because of this and this reason. There are different roles in different media, and within a single media outlet, there are different professionals with whom we should work. And maybe there is something that we didn't have time to talk about on this panel. It's important to actually present publicly the names of the media who are the champions of violations of the privacy of victims, those who bring the victims into this position. And this is something that media do a lot. They speak about the identity of the media who do not comply with the ethical standards and the law. And that is something that is important for the citizens to know. The problem is probably the problem that these media are not punished. The media who practice the violation of the right to privacy get a wrong message that this is allowed. It's not that the sanctions do not exist, it's just that we do not apply them. I think that the problem is on the side of control mechanisms and institutions in charge of applying those measures. They need to apply them, and I think that this is something that we have to focus on a lot. On the other hand, I think that state authorities, representatives of the Interior Ministry and others, this is the public shaming. I think that this is also something that can help citizens realize that this type of content is not something that should satisfy their curiosity, because there are many other things with which we can satisfy our curiosity. This is something that should not be used as our pastime. This should not be a topic that we will think about if it does not serve the interests of the child, because it might be my child later, and there's not a single person here who can tell me that if tomorrow they have a child, this child will not come into that situation. This is why it is important to speak about this. We talked about circumstances. We talk about circumstances that lead to a lack of empowerment. Usually a victim can suffer greater harm than benefit from proceedings. And this is where media play a big role. We should create media space through credible and professional reporting about those topics, where victims would not constantly be in fear of additional or secondary stigmatization, and where they would not be identified based on that experience forever. So this is something that applies to the media side. I'm sure that other interlocutors deal more with the rights of victims. I, as a journalist, had the opportunity to talk to the victims of human trafficking on several occasions. And it's always important for you to understand that your goal is not to present the entire story. It's more to use the information that we have, such as statistics, some general information, to give them voice. It's not important to tell who this is. I know who this woman is, or this child. You should just use a quote, a paragraph that will make it clear to everybody that when we talk about statistics, the rise in the number of children who become victims of human trafficking, that this is not just a piece of data. This should be used as a humanizing component, rather than looking at the victims as statistics or as an accident. Yes, of course, it's important for us to realize that, unfortunately, each of those numbers within the statistics conceal a real person and a serious, tragic experience which should not be further abused. Yes, and that it also hides a person who will have to resume with her life, and we as professionals need to be there to help her. And this is an important segment in this story. Yes, a question from the audience for Miroslav, from the primary school Ištván Sečenyi from Subotica. Tatiana from this primary school about data protection in court proceedings. How permeable this is, but just briefly, because we're approaching the end. Yes, a recent example, our beneficiary who was given the status of a special sensitive witness, who was providing her testimony to the prosecutor from a separate room, through a video link, and she was asked to give her address. And in the other room, her traffickers who are there for a reason, were watching this, and she asked not to be asked this question. She begged the prosecutor not to be asked this question, but the prosecutor says no. And it is a really dedicated prosecutor who knows his job, but he simply says no. And I don't think that she needed to be that she had to give her address in order for the proceedings to go on. Yes, during the year when the instructions on humanitarian stay was adopted, we had this dilemma. And we said that there must be a address for every stay for the police. And in order to protect the victims, we quoted the address of the center. So I'm not sure why she gave her personal address. She should give the address of the center. So all the calls go to the address of the center. And this is not the center, this is the ministry. But in that particular case, the prosecutor insisted on disclosing the address in front of everybody. But this is something that we need to improve. This is one of the things, protection in court proceedings, and then also the exchange of information among different players. It should be better defined through some rule books, although I hate rule books. They are dry and nobody reads them. But I think that at least in a basic manner, this should be regulated so that I know what I should give to you and what should be too much. Yes, we also have some procedural documents that could be adapted that would regulate differently the roles of different players who are involved in the protection of victims and actions in such cases. Meter to say something about different mechanisms and instruments of protection. The instrument of particularly sensitive witness is one of the ways to protect victims in court proceedings. We also have the national rapporteur at the Ombudsman Office, and we also have local teams for combating human trafficking. Can they put this issue on the agenda in future, give it priority, and perhaps at all levels deal with the issue of privacy of victims at all levels? Not only in future, the Ombudsman has also been giving recommendations regarding the rights of the child up to now. And we expect that one of the deputies of the Ombudsman should be the National Rapporteur on Human Trafficking. This is one of the instruments of the independent monitoring of activities in the fight against human trafficking. This has been recognized as something that is lacking when we made the strategy in 2018. And I'm glad that we have been given the legal basis for establishing this institution. Of course, lately, this has been handled by the Ombudsman Office, and I think that this will be continued in future. And even the European Directive says national rapporteur or an equivalent mechanism. So the stress is on the national rapporteur, the institution that can provide recommendations to institutions, to the members of the society, to the media, and perhaps some other institutions or organizations or business associations in future. As for the local level, when we were talking previously, I just remembered this is your book, the stories told by victims of human trafficking, where girls spoke about their stories. So for some 15 years we have been suggesting the journalists not to talk to human trafficking victims directly. We always say, well, talk to the center, talk to our colleagues who work at Astra or Athena, and they will tell you about this, because each interview actually represents secondary victimization, and we will not achieve anything through it. As a result of such approach is the fact that some 5 or 6 years ago, Athena published a book presenting the stories of human trafficking victims, where in Vranje everybody read a story at the prosecution, at different institutions, and this is the way to present this. The victim does not have to be there in person. This is something that exists in the world, in larger countries where there are so many victims that the person can go from one place to another without being recognized. But we are still not such a society where victims of human trafficking can act in this way. Local teams are also a resource, because local media can also jeopardize their safety. We've had such cases where local media disclosed information that jeopardized the safety and privacy of, undermined the privacy of victims. So the work of our teams with the media, and they're already working with the media, is something that is a potential for the future. and I would ask the media, if some people from the media are listening, the Ministry of Culture has been allocating significant funds for the development of media contents.
And I'm sometimes sorry that we, mostly local media, we have here either televisions or papers or web portals, but there is no association of journalists that would apply with the project, but they're practically implementing the education of journalists and raising awareness of journalists, including editors, on the topic of human trafficking. Because you can, maybe somebody thought about that, but just think about whether white slavery is mentioned in the media as a term. So the extent to which we are using this term, this is the extent to which we are aware of the problem. And unfortunately, I think that practically half of the media are using this term, and they're not just using the term in the wrong way, but they're mixing the term, and they say in Hungary a human trafficker was arrested, but it was a human smuggler. So that is something we'll have to do in the future through the resources that we have in place, and not only in relation to human trafficking, but more generally in relation to the entire segment where the rights are dramatically violated, the rights of victims and injured parties in criminal offenses. This is actually a good proposal and a good recommendation for the media associations to apply in public calls announced by different state actors, including the Ministry of Culture and Information. We actually, in those action plans accompanying the strategy, we had the funds allocated or set aside for the media. And in conclusion, to hear representatives of civil society, I also come from civil society, so let's hear about some good examples of the protection of privacy of children that could be broadly applied among more players. So what do you think of these recommendations from the standpoint of the civil society? Let me share with you information, a piece of information with you. You know that now the General Protocol for the Protection of Children Against Violence is being developed. The existing dates back to 2005, and certain things happened in the meantime, and it has become obsolete in a way, and digital violence has become dominant, and practically no form of violence is not accompanied by digital violence. So just one example, we have this strong component of the protection of privacy, and this general protocol should provide the framework for better and more efficient cooperation and more effective cooperation among different sectors, exchange of data, what is enough, and how it can be arranged. That's one thing. And another thing is that we will go for this initiative to recognize the laws where we can improve the arrangements and include some articles dealing with security and protection of children. And to avoid situations where people will say we are from the corporate sector, we are not from the protection or the public, from the sector of protection of children or public sector, but what you are doing affects children, what you're doing for the sake of profit is affecting children, and it can put children in danger or at risk. And the third thing, it's the level of self-regulation. It's important for each organization and each association to have its own document and its own procedure for preserving security and safety of children. And as a network, we have developed a guide for organizations that can help them to embark upon that process and to recognize what already exists in terms of procedures, what can be further developed, and they can approach us and help us to create a very important policy. And in conclusion, it's important for international organizations and institutions to recognize, and they have recognized, the importance of maintaining security and safety of children, and it becomes another requirement. You cannot be a partner of international organizations if you don't have children protection policy or zero tolerance for sexual exploitation and use, and you cannot apply for grants or for some support. So it's up to us individually as parents to check that and be sure that an institution or organization or school where we send our children is taking care of security and safety of children in a systematic way. It's not implied, but we have to say that also includes privacy and protection of data. Thank you, Sasha.
It's right. It is a task of all institutions and organizations and individuals to at least dedicate some more time to thoughts about this topic and about these issues. Today, in the years to come, a lot will be switched to this online space. A lot of personal data will be in the online space, and we will see how the data will be abused in future. In this field of human trafficking, prevention, we can see that there is more and more recruitment in online. A recent survey showed that 1/3 of victims were recruited online. And in another research, I saw that 1/4 of children who had negative experience on the internet said that they did not and would not share with anybody. And this is another issue, a completely new issue. And these are all things that will spread in future, and we should think about them. There are obviously some mechanisms. It's important to use them. It's important to synchronize them. We've heard that it's necessary to create as many targeted trainings as possible and to apply best practices of certain players by the others. And let me finish by saying that the disclosure of identities or circumstances pertaining to the violence against or abuse of children is not something that is in the public interest. And if you at least click on a text talking about those issues, you should be aware that you have made another step, or how should I put it, that you were actually an accessory to, you aided and abetted the creation of more difficult circumstances for the person who was abused. I think that we have reached the end of our panel. I would like to thank all the panelists, and I would ask you to follow all the other panels that will take place in the following days. See you on some other occasion. Thank you.